Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday. I have successfully recovered from my experience with caviar. And I would say 3 out of 10 would not recommend is my official rating, for those of you who are curious. All right, it would be great if the internet would work. There it is. Okay, slowly. We're going to get chat pulled up here. And let's pause that. There we go. That's a little better. Pop out chat. The internet crashed right as I went live, so I'm just pulling it up again. I do not know who won the internet today. Elizabeth, that is so not going to happen. It's so not going to happen. Oh, man. I thought RA used Bing. Eat your heart out, Greeners. No, I didn't. I don't use Bing. Let's see. Did you barf? No, I didn't. I held it like a man when I complained the whole time. Also like a man. So that's how it went. We can talk about the unpleasantries of eating caviar later. But if you missed the podcast, that was all it was about. We basically talked about nothing else. So it was a thing. It was a thing. So hopefully you got to join us. We have a couple things to do this morning. First of all, the first place we're jumping to is going to be a court in Utah where a judge is issuing a ruling.
You look good.
And it's going to be a tiny little hearing. Might only last a couple minutes, like 3 minutes. But it could make a big impact on a major case. And that's if the judge rules that there will be sanctions against the prosecution, or if the prosecution is not allowed to introduce hearsay testimony at a preliminary hearing. These could have major impacts going forward. So we've got our ear to the ground waiting for Judge Graff to kick that off. It's going to be less than half an hour before that starts, about 20 minutes. Let's see. Franz Fitzgerald won the internet. Thank you very much, Kim, for letting us know. Fran, congratulations. Your promptness and punctuality has earned you a punishment of internet ownership. Everything campaign-related worldwide is your responsibility. Good riddance. Thank you. All right, we have a couple birthdays to celebrate as opposed to last week where we had like all of them to celebrate, but we will sing regardless of how many we have, as long as there's at least one. And we do have Mikey MAF. Mikey Maff. Do you want to be Mikey Maff or Mikey MAF? I'm going to do Mikey Maff. And then Ashley Oakes, whose birthday was yesterday. So we're going to sing to these wonderful people, and then we'll get the day started with our court hopping and watching and looking for our next big trial. All that's going to be going down today. So wherever you are, if you're able and it's legal, stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We're ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Mikey Math, Ashley Oakes, Tim, and Darlene Todd. Happy birthday to you. Got a late ad during the song, but Mikey Math, Ashley Oakes, and Darlene Todd, happy birthday. There are many wonderful days, but today is your special day, and I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be right here with us. privilege, pleasure, the honor, that's the joy, that's ours. Hopefully we can turn that joy back to you, make your day just a little more special. And begin by helping yourself to free pancakes at Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, Cracker Barrel, and Waffle House. There's something else in there. I mixed it up. But hopefully you don't miss out on your pancakes because of me, on account of my failure. Use the form, people, that was created in 2020 something. Yes, there we go. Yes, happy birthday. Wonderful day. Denny's, IHOP Village, and Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. There we go. That's the list, greeters. Thank you. Thank you. I know you typed that from memory, as you repeat along from memory every morning. All right. Wonderful to have some amazing mods here. Our mods are incredible. Absolutely wonderful. Do show them some love today. They're well worth it. Donnie Not Wahlberg, member for 1 month. Congratulations, Donnie. You're one of us now. You can never leave. We have a knowledge base. I'm pretty sure there's like a Google Doc somewhere. It's like, these are all the things RA asked for and never remembers. And it's all like 50 pages. One of them is, what's the URL for my website again? Drum solo, here we go. The astute of you may notice that I'm actually hitting my bass drum with a handheld stick. Chat is not appearing. Oh no. Chat is now appearing. Sorry about that. Big shout out to all those who have a birthday today. And once again, thank you, Donnie Not Wahlberg, for your hitting that 1 month memberversary mark. That was just wonderful. All right. Before we talk more about caviar, which I'm sure will happen, let me answer the burning questions. No, no one else in my family would eat some. Yes, I did drop it on the ground live. It was after I had sampled it. It landed right side up. And I just pretended that didn't happen, and we moved on. So that did happen. I mean, I will never, I can't say never, but I have zero intention of ever again in my life paying for caviar. And even if someone else does, I probably won't eat it. That's my conclusion. There's nothing against Marshallberg Farms. I'm sure their product, I'm sure my experience was the best it could be, thanks to them. They're not going to sponsor the show. They probably won't even sue me for my comments. But it's, I felt like I was the brunt of a joke by buying caviar, first of all. That was probably the biggest joke. And then eating it was the second joke. And I don't recommend it. 3 out of 10. 3 out of 10. If it's on your bucket list for some reason, somebody added that to your bucket list against your will, and you're like, well, I've got this one last thing to do. Sure, try it once. Regret it, but it's checked off the list. It's not good. Let's see, suitable alternatives to caviar. Let's see. First of all, diluted bay water salt on cardboard. Add motor oil to consistency. That's about it. There's just it's not good. It's not good. Number 3 was the burping. Nobody warned me about the burps that come after caviar and how much more powerful they are than the taste going down. It's like crunchy salt that cost $88. Yes, $134 to be precise. $88 was the caviar, and then you had to buy the $8 spoon, which the only thing that's good for is like taste testing at Baskin-Robbins, which I'm pretty sure once they know you used it with the caviar, they're not going to let you use in their ice cream. But that was made out of like a shell somebody found at the beach. So the $8 spoon. And then your shipping and handling and packaging was like $38 $39 on top of it. It was a lot. It was a lot. And I have regrets. I really do. Not going to happen again. Okay, I'm waiting in the waiting room for the judge to turn on the live feed of the Tyler Robinson. It's not even really a hearing. Well, it's a hearing, but it's a ruling hearing. It's the one the judge called, says, I'm just going to talk to you and then we'll be done. So it's going to be really quick. DSN, thank you. We do have the greatest mods of all. This is absolutely true. Let's see. You and Thomas ate it wrong even though you did it better. Josh, I did everything. I even had the water cracker. We tried water cracker with just caviar, water cracker. The only thing I didn't have is like the creme fraiche or whatever it is, because my stores don't sell it. Maybe that's a hint that, not good. I looked. Walmart doesn't have it. Food Lion doesn't have it. I'm not going to order something that says fraiche from the internet because, anyway. It's just expensive. Nikki Zeebs, member for 38 months, says whoop whoop. So thankful for my addict family. Appreciate you, RA, for everything you do and don't do. Tell you what, one of the don't do's is going to be is eat caviar again. I'm going to need an OG. Okay. Nikki Zeebs. OG. 38 months. And Jen Pookie, where are you at? Where are you at here with this? Did we see you on here on the list? Right there. Uno mas from my Red Courthouse. Yippee Yahoo OG. 35 months. Thank you, Jen Pookie. And Nikki Zeebs also up there. Over 30 months, both of you. Right around one just under and one just over. 3 years. Which just blows my mind. It seems like we just started yesterday. Barb Russell, say it again. We told you no milk. You told me after, Barb. After. You know me. I mean, all of you should have expected. I showed up. I literally showed you the mug of milk. The burping was caused by and amplified by all the dairy you consumed with the caviar, sour cream, cream cheese, and milk. But it tasted like caviar. I can tell you, Soko. Anyway, too much information. If you want the full experience, it's pronounced fresh. It's spelled funky. If you want the full experience, go back and watch the podcast. It's about an hour long of time. You cannot get back once watched. It will be permanently deducted from whatever total you may have. But it's a thing. Lay's potato chips for the win. Yes, if you like the taste of caviar, Lay's potato chips are the way to go. No, we told you before the caviar. I may have just ignored that because I knew you were wrong in my head, even though you might be right now. No refunds. Yeah. Stop with the caviar. I couldn't say it better myself. It just, so it didn't taste like, no, didn't. Podcast was amazing. I laughed so much. It was fun. It was a lot of fun. And I'm glad we're not going to do that again. All right. I'm sort of stalling, waiting for Judge Graff to click the button. But I do realize that when he's in charge of the camera, he waits till the very last minute, and sometimes he's late. So even though it's 10:48 right now, and, oh no. It's mountain time. What? No. What happened there? Monday, June 22nd. Let me check my my invitation one more time. It says 9 a.m. See if anyone's giving me a different feed. KSL TV's pool. Broadcast and live streaming's allowed. Right. Oh, that's Eastern time. Okay, we're good. That's Eastern time. He's starting at maximum attendees 5,000. Good. We're all set up. Math is hard. Utah's in Mountain Time. That's where the court is, down there in Utah County. Why is this important? Let me cover this just for a minute. Why is this important? Tyler Robinson and his team have been filing a lot of motions. They've been making a lot of complaints, as they do, as one would if your life was on the line. This is a death penalty case, and so they've been filing all the motions. And when they say death is different, one of the ways it's different is that every I has to be dotted perfectly and every T crossed perfectly as well, and that if there is any error, it basically causes the whole thing to be undone, and it's extremely expensive to redo, and they don't want that to happen. So they want the process to be legitimate in every possible way, that every right was afforded to the defendant, and so there would be no grounds for appeal should this go to a conclusion that reached the ultimate sentence. And so when they say death is different, you will see a judge taking extra time, allowing the defense much more leeway, filing a lot of motions, giving them opportunities to even if they miss a deadline sometimes, they'll say, but it's because of the huge amount of information that's out there, and we just got this and that, and there's a lot. Okay, a lot goes into it, and so this case will be different that way. One of the ways it's different is we usually only see sanctions pushed for by the defense in death penalty cases. A lot of these cases, it seems the defense wants the best possible outcome from their client, and they view that as life in prison without parole, not guilty. Very few of them actually come in and honestly believe that our client is 100% innocent, and this is just a travesty of justice that's been carried out against them. So they want to get death penalty off the table. They're trying every way they can. They want to use any bit of information, any bit of ammo that looks good for them to support getting death penalty off the table, and this is one of the ways they've done it. They've accused the state of violating an order or a rule that prevents the state from making extrajudicial comments to the media about the results of tests. And they did this by, one side, the prosecution says, by intentionally filing a misleading report with the court, knowing it would be made public, which it was, which stated that there was no match between the gun and the bullet fragment that was tested. That misleading, comment in that filing caused a whole bunch of media outlets, like all of them, to be like, it's not a match. Smoking gun is gone. And a bombshell. Could this wreck the case? And the media frenzy was incredible when this dropped. Everyone's like, wow, is there another shooter? Is there another gun? All these speculations went wild, and the prosecution, as they're looking at this, saying this could hurt our chances to find a unbiased jury. The way this story is just blowing up with misinformation in the public. And so the law, the same one that says you can't talk to the media, allows them to correct things that are incorrect out there. And they say that's what we did. When we talked to TMZ and had the interviews with, Fox and Friends or wherever they went, I don't know, there was a bunch of places, that it was just correcting it. And we were talking in generalities, not specifics to these tests. I don't know. The judge gets to decide if that's what happened. And one of the things the judge can decide is that, prosecution, you went too far. You said things you shouldn't have said. Now that makes it unfair for the defendant. We're still going to go forward with the case, but because you broke the rules, I'm going to sanction you. I'm going to punish you. Punish your side of the case. How do you punish your side of the case? Well, we might take one of the more extreme options off the table, like death penalty. And that would be a huge defense win. That would be massive. If they won that today, you will see smiles and cheering as they walk out of the courtroom, because that is just like it's like winning the whole trial before it happens. It's massive. So we're going to watch and see when that when that starts. Still shows it's not starting yet. And we'll go there really quickly. Let's see, that's going to be on 8 when it is. Okay. Let's close down. I'm going to punish you. You want that as a soundbite? Greeners, I'm afraid of where you're going to use it. Do you think that's how the judge will rule, in your opinion? A. Colburn, it's a great question. The judge is very measured. He's very measured in everything he does. This is Judge Graff. He's extremely deliberate and calm in his mannerisms. And so it's difficult to get a read. It's not like playing poker with somebody who looks at their cards and suddenly their eyes light up and they're like, I'm all in. You know, you'd think that they have good cards if that, is what they did. The judge doesn't show his cards very well, even though he's relatively new in this position that he's in. He's got a lot of legal experience, but relatively new as a judge here. He's very good at being measured. And the questions he asked both sides when evidence was presented during the show cause hearing about this, and the prosecution was put on the stand under oath and asked questions about what they did to who they talked to the media and who instigated what and why. His questions were very measured on both sides, and so it could really go either way, almost like a Supreme Court hearing, where you heard the first question is like, oh, he's going after that side, and then he switches and asks the other side another really hard question. He's done that to both, so this could go either way. I don't think that the state is going to lose right now. If I had to put money on it, I'd say 75% sure that the state is pretty solidly on safe ground. The way the law is written, it has verbiage that, according to how they testified, at least, seems to match up with what they did. The only catch is some of the ways it was edited on TV, which they say was different than how it was actually presented. But the way it was edited and presented makes it look like they were talking about case specifics when they weren't. If the judge thinks they were actually talking about case specifics, that's where they have a problem. And that's where we could have an issue with the possible sanction. So I'd play poker with RA. I would lose all my money, Purple Coconut. That's why I don't play poker. Court watcher Denisha, I had an epiphany. I know a lot of you like this view. You like to see behind the scenes. I thought about changing this up and cleaning up my desk up here. Obviously, we're going to keep the goat because you need that. We'll keep some of this other stuff. But I think I'm going to get a counter right here that you guys can control with a command on the screen that will switch between the number of likes, the number of viewers, and possibly the number of comments. I'm not sure on any particular live stream. That's my goal. I think we're going to do that. And it's one of those, it's called a SMIRL, S-M-I-R-L counters. So it can go up to like 99,000, which is a lot of likes. We've never had that many likes. But a lot of people, once we get over 1,000 likes, you guys can't see what the number is because YouTube sort of truncates it. And I don't want you guys to miss out on that. And I want you guys to be able to see what the actual number is at any time. And it can see, can you get a working chat command? Yes, it's just the IP changes all the time and I have to keep updating it. We'll work on that too. Anyway, so that's my idea. I'd like to make it a little more interactive. My only concern is because it's a physical counter, like one of those old alarm clocks where the little flap flipped over to the next time. It was like, it would tick, 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 tick. It can't be too loud. And I'm worried that it will be too loud. But we're going to try it anyway. So probably early July, I think we're going to get it. Because it's made in France and it takes a while to get here. It's like the Statue of Liberty. Made in France, takes a while to get here. All right. Anything else before we jump to court? It's now 11 straight up. I'm hoping the judge is on time. The join meeting button has not turned green. Check the audios. Where's audio going? It's going to Yeah, that's important. Got that fixed. Nice. You'd think he'd be on time for his own meeting. Sort of have to watch this screen nonstop for a second, so give me a moment. And as soon as this goes live, it could be over in 2 minutes. That's the depending on how verbose the judge wants to be. There's the webinar link. Copy. Put it up here. See if that's any different. Paste and go. Open WebEx. Next. Webinar's not started. The judge is late.
Hush! I'm trying to have.
So you getting it for the channel for your birthday? Josh, I just might be. Just might be. The counter's on my bucket list, by the way. It's something I've had on my bucket list since before I started a channel. I wanted a reason to have one. And
You are banished from the state of Georgia.
And it's always been a luxury item, sort of like caviar. But I could never justify it. But they just recently dropped the price, and I'm like, okay, so now it makes sense. Now
Remember in the beginning when we started 110 years ago?
Okay. Still waiting to join. Local station says 10 a.m.
Hello.
I got a stubby little pencil.
Court. I'm a member of Court Info for Utah State Courts. It's a protected little group that is the media pool in Utah. And it says 6:22 at 9 a.m. Tyler Robinson, aggravated murder, felony discharge. WebEx ruling, Judge Graff, KSL's pool, broadcast and live stream is allowed. So,
Even a blind squirrel finds a nut every once in a while.
I've been that blind squirrel. Okay. Open WebEx.
I was kicked back, taking it easy.
You wear multiple hats, sir.
She thought it was silly for doing it. Fran Fitzgerald, 24 months, 2 years, Fran. Fran, that is awesome. Thank you to everyone helping me through some hard times recently. I love this community. Thank you, RA and Mods, for such a beautiful space. Fran, that is wonderful. That's absolutely wonderful. Thank you. And this makes you an OG. Also, Verns, member for 31 months. Best 31 months ever. Thanks to all you do, RA. OG there as well. You guys are amazing. Thank you both for your support. Did Judge Simpson's channel get hacked? I don't think so. I haven't seen anything about that. Flow State. Thank you, Espar. I haven't seen anything about Judge Simpson's channel getting hacked. We might jump to Judge Dad first thing this morning as we're waiting for the Utah court to start. Should we do that? He was on Friday. Let's jump to 7, shall we?
In a very slow go.
How do you intend to pay this man?
I doing my best trying to DoorDash. It's very painful, but that is all I have right now. It was out of my car.
You're living out of your car?
Nurse for God.
Because when they cut me off of disability because I refused to take their medicine.
Nurse for God is an
44
OG.
pills, I was just waiting to die.
Oh my goodness. We jumped in at a very morbid time. I'm going to jump back out for a minute. I don't know exactly what that is. Nurse for God, 37 months on the jury. Hi, y'all. Great to be here. Absolutely amazing to have you here. Congratulations on 37 months. OG. Judge Dad is having a rough morning with that case here. I'm going to skip that one because I just don't want to start our day with something very, very depressing. Instead, we're going to go to a death penalty case. I know the logic is undeniable, but that's how we do it. Let's give her a minute to get this worked out. It sounds like she's trying to work out a payment plan for something, and Judge Dad is extremely, extremely good at working on a plan that will work for just about anybody's budget, as long as you're making some efforts. And then even if you can't meet those agreements that you set up, he'll work with you and change that as well. So, all right, let's see. Lady Tanya in Texas, glad to be here. 18 months. You're just 2 away from OG status. Congratulations, Lady Tanya. Hope you guys all stayed safe. And I know a few of you from Texas all the way up to some of the northern states got some crazy weather in the last few days, and it's maybe not even over. So stay safe wherever you are and stay alert as to the threats that are coming your way weather-wise. Donnie Not Wahlberg gifted a membership this morning. Donnie, thank you very much. Let's see. Good morning. You pay. Good morning. I like your name. It sounds like the brand name for an arcade machine. Which, by the way, I've got a little story to share. Every time one of our children has a birthday, we let them choose an activity, a family activity. And the last child whose birthday was celebrated chose that we would go as a family. We would go ice skating. Now, being in North Carolina, ice skating is an indoor activity because ice does not happen outdoors naturally, except in a few very remote locations. And where it does, it's not thick enough to skate on. So we found that here in our little town, Greenville, there is an ice skating rink. And we went up there. And this place is like plastered with Carolina Canes or whatever, hockey banners and pictures and everything.
Hello.
And I'm like, I remember in my mind that the Stanley Cup the thing just happened, the whole Stanley Cup thing. And I'm like, so have you had a lot of, interest in skating since the Stanley Cup just went down and Carolina won? And she's like, I didn't even know they won. She's like, the owner of the rink. She's like, I don't follow hockey. I just rent out the ice rink. So anyway, we had fun. I chose not to test myself on the ice. It's not as fun, ice skating, as when I was a kid, because falling down hurts more and it gets harder to get up. But we did let all the kids go out and skate for hours. And I instead went down to the arcade room where all the arcades were overpriced and halfway broken, except for the massage chair, which I slid a nice crisp $5 bill into and enjoyed for 20 minutes of backbreaking manipulation by a machine, which knows nothing about the word ow, stop, out, ooh, ow, too much, softer. It doesn't understand any of that. It just keeps going. So if I'm walking crooked and I'm looking like I'm limping, it's because I got a massage at a $5 massage chair. Tower Hill Girl, member for 39 months. I usually lurk in a good way watching the trials, but just wanted to say thank you, all RA, for all he does. OG. Thank you, Tower Hill Girl. I love that you're lurking. This webinar just needs to happen. There's a reason we won the cup. Was it the Canes that won? Like Carolina Canes, right? Was that them? Maybe it was somebody else. Yes, it was. Well, I looked around the whole place and it was not there. I don't know where they keep it when they win. I'm guessing probably not in the local skating rink. Greeners, I have a couple massage stories. What is that fermented fish in a can? That's Jody, I want to sell my house at one point. I don't want to permanently destroy it so that nobody wants to go in it again. Yes. I don't turn on the massage chair when getting a pedicure. Those things are rough. This is not a brag. It's just facts. I ran cross country in high school, right? And something about running cross country and also being on the swim team, which involves a lot of kicking and feet and all that. Something in that process made my calf muscles just like massively defined. So almost freakishly defined. I'm not going to show you right now, but just understand that that most men would kill for legs like mine, at least the calves. Okay, they are just ripped. The muscles are just defined and everything. It's not a brag. It's factual information is all I'm sharing here. Okay, they are so strong and massive and impressive that I can't wear narrow jeans because my calf muscles don't fit in them. I'm not joking. This is like one of the trials of my life. One of the things I have to suffer through. I can't wear the narrow jeans. I crammed my legs into that massage chair, which has those two slots. It does not care what size your calf muscles are. It squeezes down to the bone. And that thing, I just about cried. Like tears welled up in my eyes as it goes to massage my calves by just like, it just crushes. It's straight up like beer cans would have crumpled under that pressure. Even full ones, not unopened. I don't know how they don't get sued, but once it starts squeezing, of course, I can't get my legs out, and you just have to just endure. But once again, I took one for the team. I do not recommend the massage chairs, at least the $5 ones. No bueno. I cannot imagine RA in skinny jeans. Thank you. Neither can I. Skinny jeans are for ladies, just saying. I need straight cut or boot cut is about the best I can do. All right, it's supposed to be therapeutic. It hurts. It hurts. My hubby delivers Amazon packages and he's quite simply put, buff. Polite one, yeah. So you understand. You understand my dilemma. I'm a massage therapist. The leg massagers are very dangerous for soft tissue damage and thrombosis. Now you tell me. No man should be wearing skinny jeans. It's right up there with the man bun and the ponytail. I agree. Strike them off the list. Flares are back in fashion. Boot cut rocks. Get on the new barrel jean trend. Barrel jean? I've never even heard of it. Right. Still looking for this meeting, which is not starting. It might be 10 o'clock. I'm looking at something on the judge's page that says 10 o'clock, but the court PIO says it's at 9. Let's jump back to Judge Dad. I think that hearing's over. Let's see how his day's going.
John, I'm sorry. You need to take this over to the Brownstown Department.
Local news said 9.
With Abington?
Steve. Wait one second. I need to know the minor damage. What is it? That one too. All right, so minor damage, no legend. Yeah. What is your name, man?
Jessica Rhodes.
Jessica what?
Anaya.
Yeah.
Did you already meet with your attorney?
Yes.
Oh.
Sloth Life saves me from public humiliation. Don't get barrel jeans. Looks like you just got off a horse or worse. Thank you, Sloth Life. Hope you're doing well.
Who is your lawyer? Okay. People versus Jason Fuller. 26W843-115. Your name, sir?
Jason Donald Fuller.
All right, so you were operating a commercial vehicle. You're going to plead to impeding traffic, correct?
Correct, sir.
To that charge, responsible or not responsible?
Responsible.
Plea is accepted. 180 is your total. Original charge dismissed. You can go down the hall and take care of that. Good luck.
We're hearing now that some people are saying the hearing's going to start in 15 minutes with Judge Graff. Thank you for the links for the barrel jeans. Oh, well, they full on make you look like you're wearing a set of chaps underneath your jeans. That's impressive. I don't think I'll wear those. I also didn't jump on the MC Hammer pants, parachute pants, when those were in fashion for the week that happened. So I'll pass. I'll pass on the barrel jeans.
I don't know which of these to switch this date. They don't have it marked in any form.
Judge has tech problems here.
You know these things. If it's moved to 22nd. All right. People against James Christopher Allen.
1 second.
Okay.
James Christopher.
People against James Christopher Allen, 26W843-186. Sir, your name?
James Christopher Allen.
All right, so you're going to plead to impeding traffic. They're going to dismiss the following too closely, right?
Yes.
To that charge, responsible or not responsible?
Responsible.
Plea is accepted. Original charge dismissed. 155. And you're all set. You can go right down the end of the hall to the cashier, okay?
Sort of quiet in his courtroom for this early in the morning.
Let me keep it informed. Oh.
Good morning. I'm going to need Madeline here, Jessica, okay? Thanks. People against Jessica, Lynn, and I at 25R514-118A.
Good morning, Judge and staff. John Graziani, appearing on behalf of Jessica Naya, who's up there for the podium. She's done my letter. Please identify herself. Jessica.
So I initially placed the defendant on probation on May 15 of 25. Took her plea under 771.1. That was revoked when she didn't do anything. I then sentenced her to 20 hours of community service by June 1. That was March the 19th. How is she going to proceed?
Judge, we plead guilty, but of course with an explanation.
If you plead guilty here, ma'am, I want you to understand you could get 10 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights form?
Yes, sir.
The lawyer
If you plead
grabs her hand
guilty,
out
you
the
will be
pocket.
giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
To the charge, failure to provide proof of completing 20 hours of community service by June 1st, how do you plead? Sorry,
Guilty.
did you fail to provide proof of completing 20 hours of community service by that day?
I didn't.
Anybody force you to plead guilty?
No, sir.
Plea is accepted to that charge. Your name, please.
Now, my inspiration.
I don't know. That's a great question, Ninnis. I imagine the court staff stays with the court because they'd have to relearn the processes with everything else. It would be a major training issue.
What is going on here?
Judge, it's a lack of transportation. She was sharing a vehicle with her partner. The engine blew, and
When did that happen?
it happened within the last month and a half.
When?
The last month.
The last month?
It happened like May 20-something.
Well, you had to have it done by June 1, so you hadn't done anything up until the engine blew on May the 20-something?
No, all I did before that was the 8 hours of community service and the 2 court work days.
You were supposed to do 20 hours of community service. Enlighten me here.
So we're here today in 2 separate cases. The one, she did not complete any of her 20 hours. On the other case.
What other case? I'm sorry, I don't have it.
There's the furnishing alcohol to
You have that one.
Furnishing alcohol to a minor.
I thought I had another one for Jessica and I.
It's no bueno. Kids don't need that stuff.
That was the one I gave you to give to Mr. Graziani, I think.
That's the one that he just gave you back.
How many did you talk to? How many did you talk to her about?
Judge, I just spoke to her about one matter.
Which one?
It was regarding the furnishing of alcohol to a minor and also the disorderly conduct.
So the disorderly conduct, yes, it's a separate case. That's the one that you had adjourned from May 21st.
Hang on a second. I think it must be in, I don't know where it is. I gotta find that. I'll go looking. You can check. Oh, here it is. My day, jeez. Now I also have Jessica Lynn and I at 254-240. All right, so everybody's name again on this one. Sorry.
John Graziani, appearing on behalf of Jessica and I.
Your name? So on this one, she pled guilty to failure to attend her probation visit on May the 11th. Failed to pay fines and costs as ordered. And failed to clear all warrants by May 1 of 26.
Judge, again, she didn't express herself well. The car, the truck, the junk truck had been having a lot of problems. It's been back and forth with the engine did blow, and this person honestly wants to complete it. It's just
I don't know why. She just got done telling me, unless I misheard her, that the car didn't blow up until May 20th.
That's correct, Judge.
What did that have to do with her not clearing her warrants by May the 1? What did that have to do with her not paying her fines? And what did that have to do with her not reporting to probation?
Judge, what happened is she simply doesn't have transportation, is unable to make any kind of money. She was about $500 a month on a bridge card for herself. And
does she work?
She is working she's on a list at Culver's in Naples. In fact, they were kind enough to keep her on the list until the transportation issue was resolved. She and her partner were in separate shifts, so as to be in a position to make ends meet and ultimately take care of this matter, Judge. Judge, I know it's frustrating, but she's in a bad position. She really is financially.
Whoa. Who wouldn't be if you didn't work? Why aren't you working? Do you have children?
I do.
How old?
I have a 1-year-old and 13, 14-year-old.
The 13 and 14 is normally in the custody of her ex.
Is that the one she provided alcohol?
What's happened, Judge, is because of her financial situation, she's really unable to take care of the 13 and 14-year-olds, which has just led her to them.
Somebody who watches the 1-year-old when you're working?
Usually my mother.
Well, why don't you get your mother to watch her every day so you can go out and work and you won't have to be living on $500 a month? Who can do that?
Nobody.
I know it might be hard, but you got yourself into some trouble here and you haven't complied at all.
Judge, to her credit, she did put in 8 hours of community service. She did 2 days of the corporate program, and although she was late.
What did she do that on?
So that was right after she got sentenced, which was End of April, end of May. Have it in mind. I can use my computer if you want.
What I mean, I don't know what to do with her anymore at this point, to be honest with you. I'm not gonna just let this go.
Judge, I would ask that, even though it's been frustrating for everyone, particularly herself, and for Ms. Raft, is it, she needs to complete this probation, she wants to do it, and she has to face the consequences.
You could have fooled me. How?
Judge, this is an example of truly living on the edge.
I don't want to sound harsh,
you guys
but
have an Aerosmith
we
song
put
in your head
ourselves
now.
in these positions. And kids are wonderful. With them come responsibilities. And I'm just surprised you didn't take advantage of my kind gesture to let you do the community service on the other case. I've already revoked that status. You didn't go and clear any of your warrants. Maybe you don't have the money. I don't know what to tell you. If you walk in there and you talk to the judge like an adult and say, I'm sorry, and you schedule my case, you might find that they're more receptive than you can imagine.
Chuck, again, I know it's a broken record, but it is transportation, along with not being able to rub two nickels to get out of the cycle. I guarantee if this is continued, she'll make an effort, even if it's like $30 or $40 a month. I mean, it's very small, but we'll make that effort, Judge. If you did do the community service, for her to have completed the 2 days of the cohort program is not only particularly in her situation.
She did complete those right after she was sentenced. However, she has taken a trip to Miami since then.
Okay, we're trying to join the meeting right now. Sorry, we're joining the Tyler Robinson meeting, which just started just a second ago. Let's full screen view. To hide people without video. All right. Sorry about the massive jump there, but the judge just barely went live with the hearing, which is going to start in just a couple minutes. So we're going to listen in as Judge Graff makes his rulings. How do I turn off? People in focus? No. Okay. We'll let it sit here for a second. Might have to wait. Don't want to miss anything. This could be a very, very quick hearing. Mr. Robinson is going to be joining the hearing via WebEx with no camera, so he's joining from jail, so he will be listening to this, but won't be present in the courtroom. Obviously, some of the participants are not going to be present as well because this is WebEx. This is just a ruling. I'll try to stay out of the way for the most part. Lots of people present so far. Has the judge ruled if this case will be streamed or not? He has ruled that, but and this is something we can probably talk about in this delay. The ruling he made is a terrible one, Ashlam. And this is just my take. He basically said, for every hearing, every single hearing, I'm going to treat it as an individual request. So instead of saying, yes, these proceedings for this trial will be televised, and if there's an exception, we'll treat that separately, we're going to relitigate the case every time we have a hearing. I don't know why he created this work for himself, but it is a ton of work. It's a little bit of work for those of us in the media. Now somebody has to file, and we'll find out probably today that someone has filed for the to be media pool on the hearing, the big hearing, the preliminary hearing that's coming up early July. As of last hearing, nobody had. But the media has to file within like 14 days before the hearing, and then they have to apply and jump through all these hoops, which then can be objected to, and then there's a hearing to see why it was objected to. It's a mess. It is just like, it's an actual mess. That Utah County Jail in the bottom right-hand corner, you can just envision there in that picture, Mr. Tyler Robinson. That's where he is, on the other side of that computer with the camera off. Let's see. Judge is here. We're about a minute late. We've got audio turned on. Hoping everything's working. I wish we could test this. Let me see if I can pull this one up here. Christopher Ballard there is one of the lead prosecutors. We see his name's there. Jeff Gray, Kathy Nestor's here now. Ryan McBride. A lot of the big names from prosecution and defense are showing up. Just need the judge to click the button and everyone's cameras will turn on. Anyway, my frustration with the media ruling is just that it adds what I believe is an unnecessary step. This is a sort of trial where you can make a blanket ruling based on the trial, and then make exceptions as needed. And instead, we made blanket exceptions, and we're going to the number of times the media has to appear. Literally, you'll see it here. At the beginning of this hearing, you're going to see the pool media for, I believe, KSL, and probably looks like, I think it's Deseret News is the still photographer. I'll have to check. But both of those individuals are going to stand up in front of the judge and raise their hand and swear that they've read the rules and that they're going to abide by the rules. They don't foresee anything happening that would cause them to not be able to follow the rules, and then they can proceed to live stream. It's a mess. It's a mess, and we do that every single time, and that's the judge's fix. For what? Because the defense says that media is going to misconstrue something. Of course they are. They're the media. That's what they do. Hey, bud, thanks for the waters. Fully stocked and hydrated now. Deer Park Water, not a sponsor yet. They're doing that because they're being admonished for their bad behavior in previous hearings when they were filming things they shouldn't be. The things they shouldn't be, I saw allegations that they filmed something they shouldn't be. I never saw the proof. I don't know if it was ever provided, but it was just out of like an abundance of caution that this media circus rule was put in place, and I'm criticizing it because I think it could be done a lot better and cheaper for the court system, while preserving the rights of both the prosecution and the defense, and also helping ensure that we're able to, when the time comes, if we get that far, seat an impartial jury. I think there are ways to do it. Kathy misses no tricks. She's good. Can we all just agree to have one media pool team that will just apply every time and to be done with it? That's once we get to the court, the actual trial, that will take place. There will be one media team for the trial, and there will be most likely one media team for the preliminary hearing as well, which is like a mini trial, 3-4 days long. It'll be the same people every time. But during the pre-trial parts like this, it's normal for various and sundry media organizations to sort of rotate that duty a little bit, although KSL does not provide a clean feed like some of the other ones do. So let's see. Murder Show says, RA is the god of courts. Changed my mind. Murder Show, 29 months on the jury. OG. I love courts. I love how courts operate. I love the system. I love that I can voice. Well, first of all, I have the utmost respect for Judge Tony Graff Jr. It's not easy doing what he does. This is a very high pressure situation, and this is not the only situation he's in. He's got a whole bunch of work that he does that with this level of precision and care. I just think that there could have been an easier decision that would have saved him and all of us a lot more time and effort while still preserving the rights and concerns of the parties at play. Remember the Alec Baldwin trial, always worth pleading not guilty. That was a big one. They filmed computer screens and fixated on Tyler Robinson. Graff said stop it, and they did it again, after which they had their public shaming every hearing. Hang on one second, I'm trying to see this last message. What? Okay, any second now. Yeah, somebody texted me saying what the results of this hearing were. The judge has not announced it yet. I'm monitoring the AP feed as well, the Associated Press, which is monitoring this, and they don't have it either. So I seriously doubt some out-of-state news channel has got a scoop on what the judge is about to decide. Tyler Robinson hearing. Okay, I've got the AP and East Idaho News, both of which are watching the same live feed that we are. Let's see. Delina Foster, member for 25 months. Oh, gee. Good morning. All right, did your daughter have fun at camp? Did you see any alligators? She saw no alligators. There was one snake that they tried to pick up. They didn't know what kind it was. And she wisely told the others it probably was not the best idea to pick up a snake if you don't know what kind it is. And no bears. And she had a blast. She loved it. Elizabeth says, listening while getting ready for my post-op. So grateful for y'all and the distraction from the pain. I'm glad we can help a little bit. Get feeling better, Elizabeth. Get feeling better. We need you back at full strength. Why no video for TR? Because this is just a ruling hearing. This is not a big... Well, it makes a big deal in his case, but it's not something where we have witnesses called in, testimony given, extensive argument. We're not expecting any argument other than possibly the media coverage portion, which the judge may or may not do today because it's so quick. Honestly, it's very possible that the media hoops he jumps through are longer than the rest of the hearing today. That might show you how sort of funny the process is. Hi, Nate Eaton. Is Nate Eaton here? Oh, East Idaho News. He's on his own channel. Let's see. There's a box for Utah County Jail. Yes, that camera will not be turned on. That was decided last time. His lawyers asked that he appear over WebEx and no camera. I mean, they could turn it on. It's possible, but they've told us they're not going to. It's like waiting for a pot of water to boil. Nate is one of the good ones. I really like what he does. Brian Enton, Nate Eaton, both great reporters. Will we be able to hear them though? We should be able to hear them. I've got the audio that I can bring in from a couple different directions, and actually do a little. Let's get something ready just in case. Box 3 is going to be 6. Box 4 is going to be 8. Let's turn off box 2. Where's that happening?
Hello.
All right. We're fixing it. Okay. We've got a safety in case our audio does not come through. So We'll have it. I'm watching multiple feeds.
I saw a chicken fight.
Is 6 making audio? You're welcome. Judge said the hearing will start shortly. You put that in chat for all of us, so hold tight. Skybell OG, 34 months. That's wonderful. Congratulations, Skybell. Very close to the 3-year mark. Fun Georgia Mimi, welcome to the gallery. Thank you. Delina Foster, member for 25 months. Appreciate the inquiry about my daughter. She loved it. The other part of this hearing, other than the death penalty, the potential death penalty sanction, is that in the preliminary hearing that's coming up early in July, the first week or two of July. In that hearing, the prosecution intends on presenting hearsay evidence. This is police officers who will be testifying as to what witnesses told them. And under Utah rules, that normally is allowed at a preliminary hearing. In a trial setting, it would not be allowed generally, without an exception to hearsay qualification. Drama Llama Mama, why isn't media allowed to show TR's face? They're just not allowed to zoom into him. So it is allowed, but they're not going to, it shouldn't be visible today because he's not turning on his camera or his microphone. Law is law. Yeah, but the judge can adapt, and he has the ability to restrict or limit some of the actions that are allowed under law. What was the very first trial you covered? Darrell Brooks was the first one we actually covered, but you might have seen me in the Johnny Depp, various pages during Johnny Depp or earlier. Some of the girl that killed the boyfriend in the shower or whatever, shot him in the shower and lied about it. That one was I was in that one as well. Goldilocks, my imagination takes me to conspiracy theories on this one. There are a lot of conspiracy theories out there. So part of the problem of the conspiracy theories, as far as where they came from, they originated from some of the filings that the defense did, and maybe that's intentional. All right, we've got some got the judge showing up at least. There we go. Can't hear anything. Turn on 6.
Counsel, please enter your appearances.
Good morning, Judge. Chad Grunander, Ryan McBride, Jeff Gray, and Chris Ballard for the state.
Good morning.
Good morning, Your Honor. Kathy Nestor, Stacy Visser, Michael Burt here on behalf of Mr. Robinson, and if maybe we could just check and make sure he can hear us.
Mr. Robinson, can you hear us? All right. Good morning to you all. All right. I apologize for the slight delay. There was a couple of last minute things I needed to do as it relates to this case. So I appreciate your patience. I know your time's important, and the court respects that. And before we begin, counsel for the state, could you provide a brief status update regarding discovery?
Yes, Judge, I'll ask Ryan McBride to do that for the state.
Tried to find out why the audio's not syncing.
We just, I think it was just late last week, we provided 12 additional files. I think that's a duplicate share. That was reports from the ATF labs. That brings our total back up to approximately 100% of what we have has been shared.
All right.
Approximately 100%? Approximately 100%?
Right, and anything, does the defense need the benefit of the record as it relates to that issue?
No, Your Honor.
All right. Turning to defense's motion for order to show cause. The parties submitted additional briefing on June 17th and June 18th, with the most recent filing being received at approximately 9:21 on June 18th. The court intends to consider all briefing and arguments submitted by the parties before rendering its decision in the interest of justice and to ensure the constitutional rights of all parties upheld. Because the most recent submissions were filed shortly before the anticipated ruling, the court requires additional time to complete its thorough review. The court recognizes the importance of the issues presented and will issue its decision on a schedule that will be announced at the conclusion of today's proceedings on the remaining matters. And those remaining matters are the defendant's motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Utah Rules of Evidence to sanction the admissibility of hearsay evidence to establish probable cause at the preliminary hearing and defendant's application for certification for attendance of an out-of-state witness and state's motion to quash subpoenas. And so the court will issue its ruling first on its motion in limine. And I'll be reading from the order that I intend to upload on the docket later today. In his motion in limine to preclude the utilization of Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Utah Rules of Evidence, defendant Tyler James Robinson seeks an order preventing the state of Utah from relying on hearsay to establish probable cause at his upcoming preliminary hearing. The motion was fully briefed. The court heard oral arguments on June 12, 2026. Now, being fully advised of the premises and relevant legal authorities, the court hereby respectfully denies the defendant's motion for the reasons set forth below. In Utah, the primary purpose of the preliminary hearing is limited to determining whether probable cause exists. In counsel, as I have done in the past, I will omit the citations, and that will be in the full order that's uploaded. Although the preliminary hearing is a critical stage of the criminal process, it is not a trial and does not involve a determination of guilt or innocence. And let's see, I'm sorry, I lost my place. The court does not understand this principle to mean that constitutional protections are categorically inapplicable at a preliminary hearing. Rather, because a preliminary hearing serves the limited purposes of determining whether probable cause exists, the scope and operation of a particular constitutional protections must be evaluated in light of that purpose. Accordingly, the court addresses defendants' constitutional arguments individually while recognizing that the procedural safeguards required at a probable cause determination need not mirror those required at trial. Defendant raises several constitutional objections to that conclusion. Defendant argues that permitting the state to establish probable cause through hearsay evidence violates his rights under the 4th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as separation of powers principles. Of the constitutional rights defendant seeks to fully invoke at the preliminary hearing, Utah courts have directly addressed the application of only one, the right to confrontation. The court recognizes that defendants' constitutional concerns are substantial and warrant careful consideration. Nevertheless, the court's analysis is guided by a limited function of the preliminary hearing and the governing precedent interpreted in Article 1, Section 12, TOS Constitution. A defendant at a preliminary hearing faces only a probable cause determination that is subject to a significantly lower burden of proof, whereas at trial, that same defendant faces a determination of his guilt or innocence that must be established beyond a reasonable doubt. Considering the distinction between the issues and the purposes of the two proceedings, the Timmerman Court believed a relaxed application of the defendant's constitutional right to confrontation at the preliminary hearing was entirely appropriate. Although Utah courts have not addressed what is the appropriate application of other constitutional rights at a preliminary hearing, this court follows the Timmerman Court's reasoning in concluding that a relaxed application of defendants' constitutional rights at the upcoming preliminary hearing is likewise appropriate because of the limited purpose of the proceeding. For example, defendant argues that permitting the state to rely on hearsay evidence, reliable hearsay evidence, deprives him of his Sixth Amendment right to effective counsel before it prevents his counsel from utilizing all the tools of effective advocacy, namely the right to cross-examine any hearsay declarants. Defendant's arguments rest on the premise that effective assistance of counsel requires access to the full range of adversarial tools, including cross-examination at every stage of the criminal proceeding. The court is not persuaded by defendant's argument. The full application of a defendant's right to counsel at a preliminary hearing, which is limited to a probable cause determination, need not be as exhaustive as it must be at trial. The right to counsel may be tailored to the proceeding at hand. The same can be said for the protections under the 14th Amendment's Due Process Clause. At minimum, due process requires notice and an opportunity to be heard in a meaningful manner. The specific procedures require, however, I note some things that I need to, minor issues.
He's editing as he reads.
Changes right now. However, depend upon the nature and purpose of the proceeding at issue. Because a preliminary hearing is limited to determining probable cause rather than guilt or innocence, due process does not necessarily require all the evidentiary safeguards applicable at trial. The court is likewise unpersuaded that the Eighth Amendment is implicated by the challenged procedures. The Eighth Amendment authorities cited by defendant concern the reliability required in the proceedings that determine guilt or authorize punishment, particularly capital punishment. A preliminary hearing performs neither function. It serves only to determine whether probable cause exists to believe the charged offenses were committed. Because defendant's guilt, innocence, and punishment are not at issue during the preliminary hearing, the court concludes the Eighth Amendment concerns identified by defendant are not implicated at this stage of the proceedings. As for the defendant's argument that Article 1, Section 12 of the Utah Constitution and Rule 1102 of the Utah Rules of Evidence create an unconstitutional mandatory presumption of reliability and results in inappropriate burden shifting, the court does not find this argument persuasive. The presumption of reliability is confined to the presumption that the hearsay evidence is admissible. That the presumption does not require the magistrate to find the evidence credible or that it supports a finding of probable cause. The magistrate still retains the ultimate decision-making authority on whether probable cause has been established. Admissibility and evidentiary weight remain distinct concepts. Although Article 1, Section 12, and Rule 1102 permit the admission of reliable hearsay, they do not require the magistrate to accept that evidence as credible or sufficient to establish probable cause. And as probable cause determination remains in the hands of a magistrate, a judicial officer, Article 1, Section 12, and Rule 1102 have not violated the separation of powers principles. Based off the foregoing analysis and findings, the court issues the following order. Having carefully considered defendant's constitutional objections, the governing provisions of Article 1, Section 12 of the Utah Constitution and Rule 1102, and the applicable authorities, the court concludes that the challenge provisions may constitutionally be applied at defendant's preliminary hearing. Accordingly, defendant's motion is respectfully denied. And that concludes the order as it relates to reliable hearsay in 1102.
So we'll get
Court now
hearsay.
turns to the second ruling, order regarding defendant's application for a certificate of attendance of out-of-state witness in state's motion
This
to
is the
quash
minor issue.
subpoena. Give me one moment here. I just need to get a drink of water.
This is a minor issue about a witness from out of state. And
again, I will omit the citations, but it will be included in the full order that is uploaded
can
to the
be
court.
Brought in.
This matter comes before the court on defendant Tyler James Robinson's application for certificate of attendance of out-of-state witness under Utah Code, Section 77-21-3. Defendant seeks to compel the live testimony of Lance Twiggs at the upcoming preliminary hearing. The state opposes the application and seeks to quash the subpoena. Having reviewed the briefing and the pertinent legal authorities, the court issues the following decision and order. Defendant is charged with aggravated murder, felony discharge of a firearm, obstruction of justice, tampering with a witness, and violent offense committed in the presence of a child. Lance Twiggs allegedly resided with and was in a romantic relationship with defendant at the time of the alleged offenses. The state does not intend to call Mr. Twiggs to testify live at the preliminary hearing. Instead, the state plans to establish probable cause through reliable hearsay, specifically a video recorded interview of Mr. Twiggs conducted pursuant to Utah Rule of Evidence 1102. The state will also rely on electronic messages, a handwritten note, and other corroborating evidence. According to the record before the court, Mr. Twiggs allegedly made statements to investigators indicating that defendant confessed to the crimes, concealed the weapon, disposed of clothing, and directed Mr. Twiggs not to contact law enforcement. Defendant seeks to compel Mr. Twiggs' attendance from Texas to provide live testimony. Defendant asserts that he intends to cross-examine Mr. Twiggs extensively concerning the reliability and credibility of his statements, his immunity agreements with the state and federal prosecutors, his state of mind, and the surrounding circumstances of the alleged offenses. When Mr. Twiggs' counsel declined to accept service of a subpoena, defendant sought this court's intervention to certify the out-of-state subpoena. The preliminary hearing is a fundamental procedural right under Article 1, Section 13 of the Utah Constitution, but its purpose is strictly limited to determining whether probable cause exists to bind a defendant over for trial. To prevail, the state must present sufficient evidence to support a reasonable belief that an offense has been committed and that the defendant committed it. Under Rule 7B of the Utah Rules of Criminal Procedure, the probable cause determination may be based in whole or in part on reliable hearsay. While Rule 7BA states that a defendant may call witnesses and cross-examine adverse witnesses, the right to subpoena witnesses is not absolute. Under Rule 14A2, the court may quash or modify the subpoena if compliance would be unreasonable. The Utah Supreme Court has repeatedly emphasized that a preliminary hearing is not a trial on the merits, but a gateway to the finder of fact. Consequently, the magistrate's role is not to weigh credible but conflicting evidence, nor to eliminate alternative inferences favoring the defense. Such tasks are reserved for the jury at trial. A magistrate may only disregard evidence if it is wholly lacking and incapable of creating a reasonable inference. Recently, in State v. Lopez, the Utah Supreme Court clarified the intersection between a defendant's right to call witnesses at a preliminary hearing and the court's authority to quash subpoenas. The court held that a subpoena compelling an alleged victim to testify at a preliminary hearing is unreasonable and should be quashed unless defendant demonstrates the subpoena is necessary to present specific evidence that is reasonably likely to defeat the showing of probable cause. Defendant argues that he has a constitutional right to compulsory process under the Sixth Amendment in Article 1, Section 12 of the Utah Constitution, as well as a right to call witnesses under Rule 7b. Defendant contends that Mr. Twiggs is central, highly material witness whose testimony touches on nearly every charge and enhancement. Defense counsel argues that Lopez was specifically tailored to protect the constitutional rights of victims pursuant to the Victims' Rights Amendment. And because Mr. Twiggs is not a victim, Lopez does not directly apply. Defendant asserts that he must be permitted to test Mr. Twiggs' credibility, the circumstances of his immunity, and the reliability of his statement through live cross-examination. The state opposes the certification and moves to quash the subpoena. The state argues that the preliminary hearing are no longer discovery devices, having been strictly limited to probable cause determinations. Furthermore, the state argues that the Utah Constitution expressly permits the use of reliable hearsay at preliminary hearings, a practice which would be eviscerated if defendants could routinely subpoena the hearsay defendants. The state relies on State v. Schmidt and State v. Robinson to assert that credibility weighing at this stage is extremely limited, rendering defendants' stated goal of testing credibility immaterial to the probable cause analysis. Thus, the state argues the subpoena is unreasonable under Rule 14a(2). The court expresses no opinion regarding whether the state ultimately will establish probable cause. The court addresses only whether the subpoena should be enforced based upon the party's current proffers. The proffered evidence, including statements that the defendant confessed to shooting, hid a rifle, changed clothing, and directed Twiggs to withhold information, is directly material to the elements of aggravated murder, obstruction of justice, and witness tampering. If this evidence is presented at the hearing and evaluated under the governing preliminary hearing standard, which requires the court to view it in the light most favorable to the prosecution, as required by State v. Schmidt, it would constitute evidence from which a magistrate could find probable cause if credited under the standards governing preliminary hearings. A central dispute is whether the standard established in State v. Lopez applies to Mr. Twiggs, who is a non-victim witness. Defendant correctly argues that Lopez arose in the context of a subpoena directed to an alleged victim and that the Utah Supreme Court's analysis was informed in part by the protections afforded under the Utah Victims' Rights Amendment. The court agrees that Lopez cannot be read without attention to that context. Victim status mattered in Lopez because the subpoena imposed burdens upon persons whom Utah law independently protects from unnecessary harassment, delay, and re-traumatization. Although Lopez arose in the context of a victim subpoena, its discussion of Rule 14a(2) provides guidance concerning how courts evaluate reasonableness in light of the limited purpose of a preliminary hearing. The court need not decide whether Lopez's precise holdings extend to all non-victim witnesses. Even assuming it does not, the same Rule 14 reasonableness considerations identified in Lopez support denial of the requested certification under the circumstances presented here. The Lopez court emphasized several principles that are not dependent upon victim status. 1, a preliminary hearing is not a discovery device. 2, the Utah Constitution permits the state to establish probable cause through reliable hearsay. And 3, the magistrate's role is limited to determining whether probable cause exists, not to resolve ordinary credibility disputes or weighing competing evidence.
Defense is losing
Those structural principles apply regardless of whether the subpoenaed witness is a victim, an eyewitness, a cooperating witness, or other hearsay declarant. Accordingly, the court relies primarily on Rule 14a(2) in the limited purpose of a preliminary hearing. The court references Lopez only because of its discussion of reasonableness informs that analysis. Whether Lopez formally governs subpoenas directed to non-victim witnesses need not be resolved to decide the present motion. The court's ruling does not depend upon extending Lopez beyond its facts. Rather, Lopez is persuasive authority regarding the application of Rule 14a(2)'s reasonableness requirement, while the court's holding rests independently upon Rule 14a(2), Rule 7b, and the limited functions of a preliminary hearing. The court also considers defendant's constitutional arguments. The Sixth Amendment in Article 1, Section 12 of the Utah Constitution protected defendant's right to compulsory process for obtaining witnesses in his favor. That right remains important at the preliminary hearing stage, but operates within the procedural framework governing probable cause determinations. Accordingly, the relevant question is not whether defendant may compel Mr. Twiggs' testimony at trial, but whether the proposed testimony is necessary to present evidence reasonably likely to defeat probable cause at this preliminary hearing stage. The court recognizes that compulsory process serves interests distinct from confrontation and discovery. Nevertheless, at the preliminary hearing stage, those interests must be evaluated within the procedural frameworks governing probable cause determinations and the limitations imposed by Utah law upon that proceeding. The court determines that compulsory process does not automatically require live testimony from a hearsay declarant at a preliminary hearing merely because a defendant seeks impeachment. Whether compulsory process requires live testimony depends upon the relationship between the proposed testimony and the probable cause determination at issue. Under the circumstances presented here, defendant has not identified testimony reasonably likely to negate probable cause, and the court therefore concludes that compulsory process does not require certification of the subpoena. For these reasons, the court need not determine whether Lopez formally governs subpoenas directed to non-victim witnesses, even assuming it does not. The Rule 14A2, reasonableness principles discussed in Lopez supports the result here. The question remains whether the defendant has demonstrated that the proposed testimony is necessary to present specific evidence reasonably likely to defeat probable cause rather than merely impeach the credibility of the state's evidence. Even under the framework discussed in Lopez, a subpoena survives a motion to quash only if the defendant demonstrates that the testimony is necessary to present specific evidence that is reasonably likely to defeat the showing of probable cause. Defendant asserts he wishes to cross-examine Mr. Twiggs on his reliability, credibility, immunity, state of mind in the surrounding circumstances. Under Utah law, this does not establish a basis to require live testimony at a preliminary hearing. As established in State v. Ramirez and State v. Schmidt, a magistrate may not weigh credibility, but conflicting evidence. Even if the defendant's cross-examination successfully exposes inconsistencies in Mr. Twiggs' statements or highlights his motives to lie due to his immunity agreements, the magistrate is required to draw all reasonable inferences in favor of the state. Evidence demonstrating bias, motive, immunity benefits, or inconsistent statements may be highly relevant at trial and may provide fertile grounds for cross-examination before the ultimate trier of fact. The court does not minimize the significance of immunity agreements as potential sources of bias. Rather, under the governing preliminary hearing standard, such evidence affects the probable cause determination only if it eliminates the reasonable inference arising from the state's proffered evidence. However, under the limited function of a preliminary hearing, such evidence defeats probable cause only if it would render the state's evidence incapable of supporting a reasonable inference that the defendant committed the charged offenses. Absent such a showing, the court may not resolve competing credibility determinations or weigh conflicting inferences against the state. Even assuming defendant successfully elicited the anticipated impeachment evidence regarding bias, immunity, motive, or inconsistent statements, the court cannot conclude on the present record that the state's proffer would become wholly lacking or incapable of supporting a reasonable inference of probable cause under the standards governing preliminary hearings. The court recognizes impeachment evidence may, in an appropriate case, undermine probable cause where it demonstrates the state's evidence is so unreliable, internally inconsistent, or otherwise deficient that no reasonable inference supporting probable cause remains. In such circumstances, impeachment evidence may do more than merely challenge credibility. It may negate the evidentiary foundation necessary to support bindover. Defendant has not made that showing here. The anticipated examination concerns matters that would generate competing credibility inferences rather than eliminating the reasonable inferences supporting the state's showing. Nothing in this ruling should be understood as creating a categorical prohibition against subpoenas directed to non-victim witnesses at preliminary hearings. The court concludes only that the defendant's present proffer does not identify testimony reasonably likely to negate probable cause under the circumstances presently before the court. The court also notes that the defendant seeks compulsory process through the interstate witness certification procedure, which imposes burdens upon a non-resident witness in a sister state court. While not dispositive, those considerations further inform the Rule 14 reasonableness analysis. Under the record presently before the court, the defendant has identified anticipated impeachment and credibility evidence, but has not identified specific testimony reasonably likely to negate probable cause. Given the limited purpose of the preliminary hearing and the state's ability to proceed through reliable hearsay, the court concludes that enforcement of the subpoena would be unreasonable under Rule 14A2. This ruling rests on defendant's present proffer and the record currently before the court. The court need not decide whether different circumstances, a different evidentiary showing, or a different category of witness would warrant a different result under Rule 14A2. The court's ruling is procedural rather than evidentiary. Nothing in the decision and the order should be construed as a determination regarding the credibility, reliability, weight, or ultimate admissibility of any witness, statement, or item of evidence that may be later presented. Those matters remain for determination under the governing standards applicable at the subsequent stage of the proceedings. So under findings, the preliminary hearing is limited to determining probable cause and is not a discovery device. The state is constitutionally permitted to rely on reliable hearsay to establish probable cause. The record presently before the court that the proposed examination is directed primarily toward credibility, bias, reliability, and impeachment rather than toward evidence likely to negate probable cause. Applying Rule 14A2's reasonableness requirement in light of the limited purpose of a preliminary hearing and the authorities discussed above, defendant has failed to identify specific anticipated testimony that is reasonably likely to negate probable cause as distinguished from anticipated impeachment that would merely create competing credibility inferences. Therefore, enforcement of the subpoena is not warranted on the present record. Based off the foregoing analysis and findings, the court issues the following order.
It's almost done.
Hereby order that the defendant's application for certificate of attendance of out-of-state witness is respectfully denied, and the state's motion to quash the subpoena is granted. It is further ordered that this denial is without prejudice and subject to renewal, because probable cause determinations necessarily depend upon evidence actually presented. This denial is without prejudice. If the state's presentation materially differs from the proffer presented before the court, or if defendant can identify specific testimony reasonably likely to negate probable cause, defendant may renew the request. And that is the order of the court.
He left the door open for them, but that's a long way of saying
again,
no.
The court anticipates filing that at both of these today.
Here's the big one. Ms. Nestor is gearing up. This is huge.
Be the controlling order.
This is the death penalty one coming up
issues. Now. Now I understand that there is another outstanding motion that was filed around the same time. I believe it was Thursday evening regarding the EMC electronic media in the courtroom. Does the parties anticipate when briefing will be completed?
Judge, the state anticipates relying on its previous arguments with respect to the media's presence and the openness of this proceeding. Again, we encourage an open and transparent process that the citizens can follow, and so they can trust the process. So we do not anticipate filing a written response to that, and we'll rely on our prior arguments and submit it to the court.
All right. And does the defense want to be heard on that issue?
Our objection yesterday, so that is before the court.
All right. Well, what I hope to do is issue a ruling on that, as well as the order to show cause issue. and again, the parties, and namely the defendant, is entitled to that ruling before the hearing in order to properly prepare, and the court respects the time necessary to prepare from both sides and wishes to issue a timely order. Let's see if we can find a hearing date between now and the prelim. And again, in regards to the order show cause, just to help give some guidance, the court prioritized the motions that would affect the preliminary hearing. Not to say that the order show cause isn't important, but that does not weigh upon issues that could result in delay of the preliminary hearing. So I just wanted to offer that background in regards to the delay of that ruling. All right.
He's delayed.
Let's see.
The
Today
death
is the
penalty ruling.
22nd, and how quickly this month is passing.
How quickly?
Let's see.
2 days is a state holiday, July 24th. It's basically like the founding day of the state of Utah.
Availability on, I know my staff isn't aware of this date, but availability of the parties on this Friday at 8:30. Again, I'm trying to get a quick turnaround for you in respect of your time and preparation on a ruling on both of these issues, the order to show cause and the motion filed yesterday.
What date is available, Your Honor?
That's the 26th.
All right. And so I see Ms. Visser nodding her head. Ms.
Yes,
Nestor?
the defense, I'm sorry, I was trying to unmute. I was having trouble unmuting. The defense will be available, Your Honor.
All right. So June 26th at 8:30 in the morning. And the court anticipates starting promptly. Again, I apologize for today. There's always last minute edits that one has to make, and I'd rather be concise and
preach,
on point
Judge, preach.
Come in not exactly where I want to be. Right, so we'll plan on June 26th at 8:30 in the morning, and that leaves one last issue, and the court wants to put all parties on notice, and and because this preliminary hearing will be open to the public, that the court is not allowing any electronics into the courtroom, not laptops, electronic devices, electronic watches, electronic or Google glasses or Android glasses, or however they want to be determined. The court is stating that for only the preliminary hearing, that any and all electronic devices must be left outside the courtroom, not just in your pocket. So no cell phones, laptops, tablets, electronic watches, any electronic recording device or electronic glasses will not be permitted at the courtroom. And if you have it, you will be turned away. And the reason for that is the court wishes to uphold the dignity and the civility and uphold the constitutional rights of all parties in this courtroom. And that is the best way the court sees to be able to do so. There will be a unique seating arrangement at the preliminary hearing to accommodate as much as the press and public that can be safely admitted and for an orderly courtroom. And the court will advise all the parties as we begin those proceedings on what's in the decorum order, highlighting a few points, because all parties are entitled to be treated with dignity and respect within those proceedings, and the court will exercise all of its powers to ensure that that is done. So I just want to put that on the record. This does not apply to the attorney. So if you're worried like, oh no, I can't bring my laptop, absolutely. You can bring your laptop and your cell phones, because I know that communication and your reliance upon that is necessary in order to properly do your job. So as it relates to the public, to the press who are excluded, obviously is counsel on record for the parties and necessary court staff. And so I just wanted to put that on the record well ahead of the prelim, so there's no questions or concerns that may arise. Counsel, with that, is there anything else that this court can address today? And Mr. Burt, your mic is muted.
Mr. Burt, speak up. There you go.
All right, give it a try.
How's that?
That's perfect. I do that once a day, so I know how that feels.
Michael Bird for Mr. Robinson. Judge, in light of the court's rulings today, I do have one logistical issue I'd like to raise with the court, if I might.
Yes.
As the court might be aware, we have arranged to bring to the hearing 7 forensic witnesses. The state has identified a number of hearsay reports. I think they're exhibits 30 through 34 that they intend to introduce. And we in turn have arranged with the federal authorities to fly out from the East Coast 6 of those forensic examiners. And then we have a 7th examiner who resides in state. And in light of the court's ruling, I'm wondering if the court, and no, the state has been kept abreast of our attempts to subpoena these people. No objection to that testimony has been lodged so far by the state, but in light of the court's rulings today, I anticipate that there will be objections to the admissibility of those 7 forensic experts. And what I think would be in the interest of everybody, including the court's schedule, is if we could resolve the issue of whether those witnesses are going to be permitted either before the preliminary hearing or at the very latest after the state presents its prima facie case, because we will have those people ready to fly out. And if we can get a ruling from the court before that actually happens, we could perhaps shorten the hearing considerably and also alleviate the expense and inconvenience of flying 6 people from the East Coast. I have not had time to discuss this with the state, and I know the state had not heard the court's ruling until this morning. But in light of that ruling, I'm wondering whether the court could take up either on Friday or at some date before the preliminary hearing any objections the state might have to calling those 7 forensic experts.
All right. I appreciate you bringing that up, and to all parties, anything that we can bring up prior to the prelim serves us well in regards to time management. Turning to the state.
Judge, we're 2 weeks out today from the preliminary hearing. Obviously, I haven't consulted with co-counsel on this, but I think we could have any objections that we may file. We haven't discussed this, but we could have those filed by Friday. If not, maybe Thursday. I'm not sure what the defense would do with respect to responding, but I think we could hear this prior to the preliminary hearing.
All right. Well, and I realize the position of both parties. I realize Mr. Burt need to wait till the ruling of the court, and I realize and I understand the state's response. Let's see what we can do to address that Friday. If briefing is completed, or if the defense needs time to respond to the state's briefing whenever that comes in, the court will be sympathetic to that and will adjust accordingly. So tentatively, we'll plan on addressing that on the 26th at 8:30. But again, I respect and I want the parties to be able to fully respond. So we'll adjust to ensure that both sides have an equal opportunity to respond to this request, and the court will take it up and address it before the preliminary hearing as soon as you can. And the court will be flexible. If it can't be heard Friday, the court will find time to hear it the following week, well before the preliminary hearing, because I understand and I respect that you need time to prepare and make best use of your time in order to do your duty and uphold the constitutional rights of all parties. So that's the best answer I can give. Mr. Burt, any thoughts?
No, Your Honor, thank you for that accommodation. I appreciate that.
All right. Any final matters before we conclude today?
No, Your Honor, not from the defense.
Not from the state.
All right. Thank you to all parties, and we'll see you on and just to clarify, on WebEx and for Mr. Robinson to defense, what's your request as it relates to him?
Same, Your Honor. If he could just be listening with no video, that would be great. Thank you.
All right. We'll go ahead and put that into place. Thank you to all your time for your time, and I wish you a good rest of your day. Court is now in recess.
Okay, so the judge pulled an audible, and and decided not to give us the answer we were looking for, which is quite interesting. He decided not to address the show cause hearing, which is the big elephant in the room, whether or not he's going to take the death penalty off the table. Instead, he addressed the two other motions, one about the admissibility of hearsay testimony at the preliminary hearing, and then the sort of like the other identical motion of whether or not to allow the state or the defense to force Mr. Twiggs, Tyler's roommate, to be in attendance at the preliminary hearing so that defense could cross-examine him as to the reliability of the statements he's credited with making. This is basically two attacks at the same issue. The hearsay evidence they're presenting will include Mr. Twiggs' testimony, his statements that he gave to police officers. And since they lost that one, it was sort of like the writing was on the wall. They were probably going to lose the other one as well, and they did. So defense was handed two losses in this hearing. The state got what they wanted in both situations, but everyone is kept on pins and needles waiting for the ruling about the death penalty, and the judge hinted that it might not even happen before the preliminary hearing. He says, I sort of focused, I prioritized the motions that will affect the preliminary hearing, and whether or not this is a death penalty case will not affect the preliminary hearing. This case would go forward either way, at least it could go forward either way. So because of that, we have to wait till later to get that. How much later? I don't know. Now, there's another motion that was just mentioned briefly, and from what I can gather, there was a filing that was made for the preliminary hearing by a member of the media, the electronic media coverage, and that starts a process with this court, and this happens every time there's a hearing. It starts a process that requires the prosecution and defense to be notified that there's a filing, that somebody wants to film this, and they get to object, which the defense always objects to. And then, the state's like, we don't care. They have the right to. We're not against it. We think it will actually help. Defense gets to stand up and say that will cause major problems. So on the Friday, the 26th, we should have the media hearing as to whether or not this is okay. So the media gets to be there saying, hey, this is our right to cover this. It's the same process we've gone through before. I'm not sure who it is, Fox 13, Channel 2, Channel 4, Channel 5. It could be Law and Crime, under the name Law and Crime, or under Court TV, which is their subsidy. It could be, we could do it. We could be out there, if we wanted to, and provide the media pool for this. But the lawyers for the coalition of media partners will be arguing that they should get to cover it, and they'll get to. There might be some testimony of children, if that's taken, which I don't think will be in the preliminary, but if there is testimony of children in the preliminary or underage individuals, they will be excluded from media coverage, but that will be a carve-out as opposed to a blanket elimination. So we should have media coverage during the preliminary hearing, either way. All right, that, I think, answers all. Oh, I need to get Alaska Court going. Oh my goodness, Alaska Court, where are you at? Turn that one off. Get this on Top Mark Media. Go live. Just one second. It is day 7. Okay, eliminate that. Go to here. Watch now. Hasn't started yet, which is good. But sorry, this is going to be over on Top Mark Media's channel, where we've been following this Alaska Court There we go. And play. Okay, as they are getting set up, let me put our logo on there. Sorry, this is this trial out of Alaska, which is about to start. Give me just 1 minute to get that configured correctly. That'll be over on the Top Mark Media channel live throughout the day as that continues. Logo. All right. Okay. Now that's a go. Even though I've not seen any audio yet. Looks like the judge. Oh, they're not there yet. That's why. All right. How's everybody doing? When I got up, I peeked at his calves. I'm not here to show off. I don't want anyone to feel bad about their chicken legs. There's no audio there yet. It looks like we're waiting for the judge to be live. We've got the witness. We've got a spare camera, courtroom camera. We've got plaintiff. And, oh, I can show you as well. This is the Alaska trial. The gentleman in the top right-hand corner in the suit with the glasses is the defendant. He's, I think, 23 years old, military member charged with murder. Judge just barely starting things up right there, but as he gets everything ready. Anyway, we're not gonna follow that. That's gonna be on Top Mark Media, so you can watch that over there. All right. Anything? South Aussie girl. I'm sorry. Get some rest. Get some rest. Let's see. Lots of court things happening, but we're waiting for our next big trial. Let me see what we have. We were with Judge Dad this morning. We want to go back and see how he's doing. I believe he's still alive. Let me check and see. No, he's in a break. Hope his morning went a little bit better. Let's see who else we have we can visit. Oh man, we haven't been here in ages, but
I don't hear. I tell you what, we'll put it on for the August date, and I'll talk to Judge Dunaway. And, you know, if he wants to take it off then, he can. Because he's in front of him, you know. He said he won't. Well, it's pretty bad charges, so. But I'll see you back in August here, okay?
Yes, ma'am.
All right, thank you, sir. Hey, let me check your body. Hold on. I'll make sure this. I don't want you to get in trouble because something on here isn't clear. Let's see.
I have a area of 955 DeSoto Street Northwest and the community surrounding. And no contact with the co-defendant, Tyrone Whitaker.
What about
What
stay
does
out of
that mean, the
Fulton County?
community surrounding it? What,
Stay out of Fulton County?
Atlanta? Just curious. Is that like,
There was some residential behind it, so I just put the zone to cover all of that.
They're
what kind of town
overmodulated.
is that in?
Southwest, Your Honor, I do believe.
Yeah, I'm trying to think. Is it? It's not Mechanicsville. What is it?
It's 955 DESOTO Street Northwest, DeSoto. Northwest.
It says Northwest?
Do they have a little name for that community, like, Mechanicsville?
Hold on, let me check, Judge, see. Yeah, that's where we need is a zip, and that would tell me where it is. But if my computer would comply.
I have it.
Yeah.
I have it on our computer, but let me see if I can just pull it up for you.
That would be very kind. Let's see here.
Do you know if they have a name for that community? Like you have Peoplestown, you have Reynoldstown, you have Midtown, Buckhead,
There it is.
Cabbage Town. So they have like a.
I don't know how to have it as Northwest, but it's 30314.
It should be.
It's
Okay.
955 Soto Northwest, Atlanta, Georgia, and then its zip is 30314, which is clearly Southwest. My alma mater is at 314. So, yeah, that's weird.
Just say stay out of Fulton
I mean, I'm
County.
gonna try to have it with that. What if it was like Reynoldstown? I'd say just stay away from Reynoldstown.
It's in the Washington Park neighborhood, Your Honor.
So you live far enough away from that?
I need to change
All
it.
right. So why don't we just modify it to the Washington Park area? Okay. That way you'll know, because if it says stay away from the area, I don't know what that means. All right. So we'll change that to the Washington Park area. That's what I was trying to figure out.
Okay.
No, that's not on you.
All right. Anything else, Ms. Burns? Yeah, let's see. Make sure we got everything right. Let me see. Was there anything else that was in your bond that maybe wasn't real clear to you?
No, that's everything.
Okay. Well, I mean, that'll at least help you because, yeah, it says, DeSoto and the community surrounding with that, no weapons, no contact with. This has your own, you have a job and stuff, so make sure you tell her where you work, all that. All right, we're good. Thank you. Have a good day.
All right, we're good.
All right, we got Tyreen Whitaker, 26 SC 001667. 26
Allie B.
SC 001667.
OG
Yes,
37
this is a
months.
public defender client. I don't have any information for the court.
All right, let's see. What do you got there? Second chance.
We do have 6 curfew violations within the last 60 days where he's leaving home and traveling at residential homes, gas stations, and restaurants. The defendant does have several dead batteries, total of 18 days, ranging from 16 hours to 160.
She sounds like Charlie Brown's teacher.
Bench warrant, and I'll let Judge Dunaway know.
You mean bench?
Obviously subject to notice. Make sure they got it. All right, last one is Giovanni Scrine.
Judge, this is also a public defender client. I think he may still be in jail. He had a recent arrest yesterday, I believe.
Yeah, he's probably still in jail then. Why is she laughing?
Looking at the charges, and I was like,
Yep, you're right. He is in jail. Let's see what is.
New charges are misdemeanors, 2 counts criminal trespass, and a simple battery.
And damage to property.
We'll, I guess, keep it on.
So he was released on 6/4. He was released that morning by 4:13. The defendant unplugged his device and he threw it over a fence. And witnesses were able to take us to retrieve that device. So the device was not even on him for a couple hours.
And then you got arrested for the other ones. And I guess it's not reporting now, right?
No, it stopped reporting on 6/4 because we went and retrieved the device after he cut it within a few hours of being released from custody.
All right, we'll do a bench warrant. Okay, now skip anybody since I'm. Uh-huh. It wasn't, is he?
the first time I seen him was,
And Your Honor, I do have that address for you.
Oh, okay, let's go back.
It's 217 Brookview Drive, Riverdale, Georgia 30274.
Where did he go? Where he said he was going to retain those attorneys. The attorney came and told me
I'm sorry, ma'am.
know what his violations were, and now they've
Oh,
disappeared.
3027.
He asked me, he's like, "Oh, do you think he's gonna go to jail?" I just report it, and now they're gone.
And maybe be excused, Your Honor.
All right.
And what's that?
Maybe be excused.
Oh, absolutely,
All right,
absolutely.
thank
She's
you.
running out of stuff to talk about. Let's see if we've got anything
All right.
else up in Kansas.
We have an issue in connection with position 5. I don't think we've had any follow-up.
Right. It's
Hey,
that
what
was
gives you a
the
break
jump.
there, Mr. Patterson?
We're going
On
to
the
jump.
record in BU 2026
Mr.
TR
Aguirre
7
in a red
11,
shirt,
State
maroon.
of Kansas versus Vitor Rico.
Thank you, Your Honor.
Mr. Rico, you're here. Thank you, sir. Jared Aguirre for the state, and defendant Mr. Rico appears in person and pro se. Let's see, sir, you are here on, well, you had first appearance before Judge Hart April 1st. You said you're going to hire your own attorney, so Judge set this on our docket today.
Where's
And
that
the court
attorney?
approved a $2,500 bond. So, where's your attorney?
I met with him. Well, I spoke with him on the 19th. I'm sorry, on the 11th, and he scheduled me to meet with him on the 30th. I paid him half of the retainer fee. I just owe him another half that I'm gonna pay him this Friday, but he didn't schedule me. He wasn't able to schedule me to meet with him till the 30th. For
You paid half
of
a
this month.
retainer.
Of June?
Yeah, of June. He didn't have any availability anytime sooner. So he asked if I could come in here and
Ask
ask you for a continuance. His name is Brian D. Nicholson here in Wichita, Kansas.
Okay, Brian Nicholson. And Mr. Regier, what's your response to request continuance? I believe my next jury trial would be, maybe we don't even, maybe this isn't set for jury trial. This isn't, is it? Is it set for, yeah, it's misdemeanor control. So we'll set this over to misdemeanor control depending on your position, Mr. Regier.
One moment, Your Honor. The state is reviewing one final matter, if the court will permit me.
Certainly.
Wait for data. What happened to which hearing, Bite Me? The Tyler Robinson one is done. You might have missed that one if you were gone. All these are other trials. Like everything we do is another trial. Just some of them were big and some of them were small. The next really big one will be the Tyler Robinson preliminary hearing, which will be about a 3 or 4 day trial, a mini trial where we get to see a lot of the evidence that the state has.
Your Honor, if the court is prepared to continue this matter, the state would have it noted that there does not appear to be any order appointing counsel or formal entries of appearance on file with respect to any alleged counsels of record. Additionally, this is a defendant who would appear to have another case currently pending in another jurisdiction, that's Sedgwick County 25 TR 15008, alleging multiple violations which appear to be reflective of the charges currently before the court in this case. That appears to involve allegations of driving while suspended, a registration violation, and no proof of insurance occurring in September of 2025. And it is further the state's information that this is a defendant who was previously convicted of a felony flee and elude in a prior Sedgwick County case. With that being said, the state is seeking an order that the defendant be ordered to appear in person for all future proceedings as an additional condition of bond.
Whoa.
Clerk Jennifer, when is the earliest available you can set this for misdemeanor control to see if he does have Mr. Nicholson hired?
We do have opening on September 14th, unless you would like me to look for something sooner.
I was thinking something around the 1st of July, maybe, just to make sure, as a control, just to make sure Nicholson actually is on board. Because we're looking at serious charges here. Mr. Regier, you didn't mention, but there's the ignition interlock allegation. There is another DUI allegation, plus those you mentioned. So from the other county.
And Your Honor, the state's information is that the allegations in the 2025 Sedgwick County case would appear to reflect counts 3, 4, and 5 of the information in this case.
And then we have 6 in this case, 83 and a 65 speed zone. So with everything combined, they're pretty serious allegations.
We could do July 13th.
All right, let's set this over to Monday, July 13th at 9 a.m. for misdemeanor control, and you must be back here at that time with your attorney, Mr. Rico.
Okay, is that at El Dorado?
It is, and I am going to honor the request that you be here in person, not by Zoom. Your attorney can be here by Zoom, but you have to be here in person. And I don't know how it is that I don't have a bond popping up here for you. Who's got a bond for him? Anyone?
Mr. Gear's like, hang on.
Oh, there it is.
Your Honor, the state's information is that a $2,500 professional surety bond was previously executed in this matter. The state does consider that a remarkably low bond given the nature of the allegations in this matter.
It is a remarkably low bond. I don't see a copy of the bond, but I do see where it looks like it was filed April 1st. So, Jen, if you want to track that down when you have time, if you get time, I appreciate it. All right, so, Mr. Rico, I'm going to continue this ridiculously low bond you have, but you make sure you're back here. It's going to be substantially higher.
Okay, absolutely, Your Honor. So July 19th?
July 13th.
July 13th? Awesome. Well, thank you, Your Honor.
You're welcome. You may go.
Bye.
How did you luck out with a ridiculously low bond?
Anybody else down there, Deputy? Other than the ones that are waiting to hear if they go or not?
No, I don't.
Darren Patterson, do you have anyone you want to take up next?
Judge, if we could take up Bruce Idris.
Okay. We're on the record in BU 2025 CR 514, State of Kansas versus Bruce Leon Idris. Please announce appearances.
Thank you, Your Honor. Joseph Baca appearing for the state of Kansas.
Your Honor, Darren Patterson appearing on behalf of Bruce Idris. Mr. Idris does appear, he is working on appearing. There he is. He's appearing via Zoom audio visual, Your Honor. Judge, this is a pretrial conference. I can tell the court that I have been discussing the case with Ms. Norris, and we are in the process of working through what I believe will be a resolution, but it is requiring that I obtain some further documents and get those to Ms. Norris. So the defense is asking for a continuance. My understanding, the state does not object.
Continuance, Mr. Baca.
Judge, that is all correct, and according to Ms. Norris's notes, and getting close to hopefully finalizing something that would take this off the trial docket.
All right, well.
And Judge, I can tell the court, I am so confident that we're going to resolve this without the need for a jury trial, that we would be fine with waiving jury trial today and setting it over for a status conference, and that's what we're working towards.
All right, Jen, when is our next, or Jennifer, when's our next status conference? We can put this one on.
September 14th, Your Honor.
This is continued at the defendant's request to September 14th at 9 a.m. Defendant is continued on bond. Well, he probably doesn't have a bond. Is ordered to reappear at that date and time. I will continue the $2,500 personal recognizance bond he posted November 26th of 25 with the conditions existing plus the added condition to reappear September 14th at 9 a.m. by Zoom, Mr. Idris.
Thank you.
You're welcome. You may go at this time.
Bruce, I'll be in touch with you.
Any of you expert designers out there want to help me out with the logo?
Without objection by the state.
Yes, Your Honor.
Okay.
Judge Patrick Chitak.
Alpha T, Tuck.
Bruce is still here. I've ordered my Smurl counter, and I need to give them a logo that they will laser engrave. So it has to be a black and white logo. Square,
we are on the record in
resolution.
BU 2025 CR 439, State of Kansas versus Patrick Michael Chitak. Please announce appearances.
Thank you, Your Honor. Joseph Baca appearing for the state of Kansas.
Your Honor, Darren Patterson appearing on behalf of Patrick Chalk, who does appear personally via Zoom audio visual. Judge, this is a case where I have filed a motion to dismiss for speedy trial. I have heard back from Ms. Norris initially just questioning whether the last continuance was was agreed to by defense or not, and I've sent over a copy of the court's notes for the state. Other than that, I don't know how the state wishes to proceed on that motion.
My notes for April 6th of 26. State requests to continue the jury trial at this time. Set over to pretrial 6/22 of 26, jury trial 6/24/26, 9 a.m. Defense objects, continuance granted. So that's what my notes show. Mr. Baca, do you have anything to respond?
Your Honor, understand that motion was going to be taken up and argued by Mr. Patterson. We would just leave that in the court's discretion. Can inform the court that on that April 6th date, my notes do reflect as well that it was the state's request.
And Judge, I think the motion speaks for itself pretty clearly. I've outlined the only time that the defense made any attempt to delay or continue, and that was at one court hearing. Other than that continuance, there had been no other continuances requested by the defense. So that with that April continuance on the state, I believe that does cause this case to be timed out.
September 22nd, 2025, before Judge Rickey, found indigent, Patterson appointed, the hearing set for December 8th.
Timed out. It might be dismissed.
December 8th.
On speedy charges, on grounds.
Set over per defense to jury trial. Is that the one you're talking about? Is the only one at your request, Mr. Patterson?
No, that was not a request for continuance. That was just setting it for jury trial.
Mm-hmm.
It's the, I think, a February one that the defense made the request for continuance.
Yeah, I do see February 23rd was set over at the defendant's request. April 6th set over, defendants objected. So, all right. We can look at that.
We don't see this very often.
9/22 of 25 to December 8th of 25. Do the parties agree that that is on the state?
We have set that out as a state, yes, Judge.
I mean, yeah, yes, Your Honor. I think it was just a first appearance requesting an attorney. I know the first jury trial request was December of 25, it appears.
Yeah. And according to case law, the speedy trial clock starts at time of arraignment. For misdemeanors, the arraignment is at that first appearance. That's when the clock starts.
That's my understanding of the law. I trust the state agrees. Mr. Baca, I'm sorry, I may have asked you, do you agree or disagree that the speedy trial is run on this?
Well, Your Honor, the state's not taking a position on the motion, just leaving it in the court's discretion. I do agree, though. I do know the April 6th date was a request for continuance by the state.
All right, well, I don't want to take the time to do the math on that right now with all the applicants this hearing.
Judge, I did the math in the motion.
Oh, you did? Okay.
Yes, I think it's in paragraph 3 or 4.
He might get this case thrown out because they didn't get to it in time, which is rare. Robinson ended already. Yes, Katrina Bunny. The state lost on both counts, but we did not get an answer on death penalty. The judge is holding out on that one. It was expected to be offered today, but he didn't do it. Come on, Darren. I want to see Mr. Patterson win this one. I don't know what the charges are.
Motion granted, case dismissed.
Dismissed. Is it with or without prejudice?
And that would be with prejudice.
With prejudice, it's done. It's
yes,
over.
Your Honor.
You can talk to your attorney more about that if you need to. Just shut up.
Thank you, Your Honor.
That's a huge win.
We'll
for
be
justice.
on the record now in BU 2026 TR 713. State of Kansas versus Dennis Jean Ephraim, or Ephraim. Please announce appearances. You may go, Mr. Phillip.
Thank you, Your Honor.
He's like, I'd like to stay around and gloat
Joseph
in my
Baca
win.
appearing for the state.
Your Honor, Darren Patterson, appearing on behalf of Dennis Ephraim. Mr. Ephraim does not appear, and we have been having a little bit of trouble getting hold of him. But I believe that he was at the last hearing when this was set. So I don't have an explanation of why he's not here.
Defendant was here via Zoom from the Butler County Detention Center. Mr. Baca?
Yes, Your Honor. I have no further information from the defendant or anything as well. If he's not here, it would be a state's request for a bond forfeiture bench warrant. If the court is looking to the state for a recommended amount, appears our prior bond was $1,500. State would recommend $3,000 cash or surety.
I'm going to set it at 4,500 cash or surety. In light of the charges. Thank you. We'll be in recess on Ephraim. We'll now take up Freeman on the record in BU 2025 CR 488. State of Kansas versus Rachel Renee Freeman. Please announce appearances.
Joseph Baca appearing for the state.
Your Honor, Darren Patterson, appearing on behalf of Rachel Freeman. Ms. Freeman does appear via Zoom audio visual. Judge, this is a case where we have entered into certain plea negotiations. Part of the plea negotiations is that the state will amend the charge to that of simple disorderly conduct. My client would be entering a plea of no contest to that charge. We would stipulate to the affidavit for purposes of that no contest plea.
Remind me what that statute was again, if you have it there, either one of you.
Yes, Your Honor, that should be under KSA 216203 and then subsection A3.
A3.
Believe so, yes, Your Honor.
Who's in Greenwood, D.C. with their feet up?
All right, Ms. Freeman, the state is amending your charge to disorderly conduct, which is one of the following acts that you knew or should have known would alarm, anger, or disturb others, or provoke an assault or other breach of the peace, to wit, using fighting words or engaging in noisy conduct tending reasonably to arouse alarm, anger, or resentment in others, a Class C misdemeanor. How do you plead to that charge? Did I hear no contest from your attorney?
No contest, Your Honor.
So by pleading no contest, you do not want to admit disorderly conduct, but you do not want to deny it and take it to trial either?
That is correct.
Is anyone making you enter this no contest plea today by any threats or promises other than your plea agreement?
No, Your Honor.
You understand that with this plea, even though you're not admitting it, you're giving up your right to a trial. You will be found guilty, most likely, and unable to appeal your conviction.
Yes, Your Honor.
All right, and then there's the affidavit you mentioned, counsel. An affidavit filed October 27, 25 by Officer Michael Weber of the Butler County Sheriff's Office. I do find the defendant not only knowingly and voluntarily entered her plea, but that the factual basis is provided by the state. I find the defendant guilty. Recommendations for sentencing, counsel?
Yes, Your Honor. Believe these are mostly joint recommendations. I know Mr. Patterson will correct me if I have any part wrong. At this time, state is recommending a 30-day underlying sentence, requesting 6 months of reporting probation. I believe Mr. Patterson is going to make an argument for non-reporting probation, requesting court costs, determine attorney's fees. If probation is ordered, state would request the standard orders of probation, as well as a special condition to follow the BIP assessment. She has already obtained that assessment. It was submitted with a prior diversion application, and then follow any recommendations on that assessment.
Very well, Mr. Patterson, anything further? Mr. Patterson, you're muted, I'm sorry.
Apologize, Judge. We would ask the court to consider non-reporting probation. The reason for that request is my client did obtain a Kansas domestic violence offender assessment, and I can tell the court it does not recommend she enter into the battery intervention program, so that since she's not doing program, we would ask for non-reporting probation, Judge.
Is she still having contact with the alleged victim?
No, Your Honor.
Okay, thank you.
Yes.
All right, Ms. Freeman, your sentence will be 30 days suspended for 6 months reporting probation. Do you work?
Yes, ma'am.
Where do you work?
Blackburn Construction.
All right. You will be responsible for your attorney fees, court costs, and the $60 probation supervision fee. You will pay that at the rate of 1/6 of the total due each month. First payment due July 22nd, 2026, and then 1/6 due on the 22nd day of each month thereafter until paid in full. You can't always pay more, but you have to pay at least a sixth. Provide proof of completion of the BIP assessment to your probation officer, and if necessary, proof of compliance. Do that within 30 days or whatever they tell you to do. All standard conditions will apply. contact probation as soon as this hearing is over at 316-3.
867-5309.
1:30, so call them later today if you need to.
Yes, ma'am.
Anything else we need to address, Mr. Baca?
I don't believe there's anything from the state, Your Honor.
Mr. Patterson, anything further?
Nothing further, Judge.
All right, Ms. Freeman, anything further from me or your attorney?
No, Your Honor. Thank you.
Thank you. You may go at this time.
Your Honor,
Yes?
I'm very, very sorry. I just want to clarify, and I don't know if the state requested, did the court order the no contact with the victim? I can't remember if I recommended that, but that was part, and I apologize.
All right, no contact with the victim is also ordered. I inquired, but I don't think I heard a recommendation. That could have been on my part.
Thank you, Your Honor.
You're welcome. Ms. Freeman is excused.
Thank you.
You're welcome.
Make sure and call probation, Miss Freeman.
Yes, call probation. All right. We'll now take up Pierce, Stephen Pierce, on the record in BU 2026 CR 29, State of Kansas versus Stephen Paul Pierce. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson, appearing on behalf of Stephen Pierce. Mr. Pierce is in my front office area. I'm going to go get him, Judge.
Very well.
Stephen, are you ready?
Stephen.
All right, again on the record in BU 2026 CR 29, State of Kansas versus Stephen Paul Pierce. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson, appearing on behalf of Stephen Pierce. Mr. Pierce does appear personally in my office. Judge, this is a case where there is a second case that I represent Mr. Pierce on, that it is a felony case currently set with Judge Satterfield for preliminary hearing July 29, 2026 at 9 a.m. Judge, this case, before the court today is it has to do with the same parties, same witnesses, pretty much same everybody. So there'd be a request by this defense that this case be continued to that July 29 date, so that both those can be handled together. I have emailed Judge Satterfield's office. I just haven't got a response back yet to make sure that they are on board with that. But generally, I haven't noticed that Judge Satterfield's had too much of an objection for that. But we'd ask court at defense request to continue this to July 29 at 9 a.m.
Well, Judge Satterfield historically is quite accommodating to help anyone out, but I know she's got quite a bit of things going on right now of her own, professionally and personally. Mr. Regier, I don't have any problem with setting that over the 29th. If Judge Satterfield can and will do it, what do you think?
Your Honor, it would appear that this is defendant with another Butler County case, 25 CR 480. State's information is that is currently set for preliminary hearing on April 29th at 9 a.m. State has no objection to continuing it over to that date and time if the court is prepared to find this is defense request for continuance, as well as continuing all prior conditions of bond, including the no contact order as previously ordered by the court on March 16th.
All right, so Judge Satterfield has preliminary hearing July 29th?
That is what the state's information is, Your Honor.
Oh, okay. Is that a docket or a special setting, if either of you know?
Judge, that is an evidentiary hearing setting, so it's special setting for it only.
Well, I feel like I should be asking her if I can take her preliminary hearing rather than giving her another. Let's see. Jennifer, why don't we keep a control date on my calendar, but we can certainly check and see what Judge Satterfield thinks about that July 29th on her docket. So just a control status, what shall we put this on? How about, do we have a July 13th? We are setting some on.
Yes, we can do July 13th.
Okay, I'm just putting it here as a keep track of it, July 13th at 9 a.m. But Mr. Patterson, if you want to check back with Judge Satterfield, and I'll try to do the same.
I will do so, Your Honor, and I will let the court know what I find out.
All right, thank you so much. Mr. Pierce, I'll continue any bond that you are on with the added condition. 2-year bond, that would be the bond of $1,000 that you posted on your own recognizance February 20th or 26th. Added condition that you reappear here by Zoom July 13th at 9 a.m. unless Mr. Patterson tells you otherwise. And he very well could. All right, nothing further. Mr. Pierce is excused.
Your Honor,
Yes.
the state would renew its request for a finding as to whether this should be a defense request for continuance, as well as whether or not the no contact order is continuing in this matter.
Continued at the defendant's request. Any objection to the no contact continuing, Mr. Patterson?
No objection to it continuing, Your Honor, yes.
All right, no contact to continue.
Judge, if I get one moment to walk my client out, I'll be right back.
Well,
Send
anybody
him back
else
out to the waiting room.
Not Mr. Patterson? Looks like they all are. And some of them still waiting since 9 o'clock to find out if they're going to trial or not. Mr. Gillette being one of them.
Mr. Aguirre, you mentioned his
Ms. Gillette, if you need to take a lunch break, we
his
can
clothing
reconvene
choice
at
is
1
on
o'clock.
point.
Would you prefer that?
His tie matches his suit, matches his eyes, matches his heart. No, I'm just kidding. Excuse me. Did I say that out loud?
And same with Mr. Cooper. Mr. Peterson, would you prefer to take a lunch break and reconvene at 1 o'clock, all of you?
Yeah, that would be fine, Your Honor. I do have a 2 o'clock.
2 o'clock? Well, I'll have to see if my Greenwood County docket would allow that. Let's see.
Red, thanks for the logo. I used it. I've
And
ordered
Your
it.
Honor, Your Honor, for what it's worth, I am prepared to continue.
I don't need
poor
food.
Mr. Revere, he's used to this grilling schedule.
His batteries
Well,
are
let me
fully
see.
charged.
Let
He
me
can continue all day long.
Mr. Patterson, I'm kicking around some of these folks that aren't used to working through the lunch hour like some of you are. Maybe letting them come back at 1 o'clock. Someone suggested 2 o'clock, but I would have to check my Greenwood County docket that usually has a 2 o'clock.
Judge, we do not have anything this afternoon for Greenwood County.
Excellent. So 2 o'clock reconvening for the docket. What do you think, Ms. Gillette? Anyone else? Mr. Cooper, 2 o'clock? What do you think? Or just keep plowing ahead?
Mr. Gear wants to just plow ahead.
Judge, I don't mind coming back whatever time the court would want to this afternoon for the ones that have been called for trial, but I do still have a couple of pleas left this morning.
All right, let's see.
Mr. Aguirre has to collect souls later this afternoon, so he's dressed appropriately.
I have Elizabeth Pipkin and Riley Batson.
All right. Well, okay, we'll be on the record in BU 2025 CR 377, State of Kansas versus Elizabeth Nicole Pipkin. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Elizabeth Pipkin. Ms. Pipkin does appear personally via Zoom audio-visual. Judge, this is a case where we have entered into certain plea negotiations, and pursuant to those plea negotiations, state has agreed to amend to 1 count of simple disorderly conduct. My client would be entered a plea of no contest to that amended charge, Your Honor.
That is your amendment, Mr. Regier.
1 moment, Your Honor.
He's like, what? We let her get away with a reduced charge? There must be a mistake.
Any of you that are here for the 2 o'clock, any of you that are here for Butler County, if you prefer to come back at 2 o'clock, you can do so. Just let the clerk know, maybe send her a chat or something to let her know that's what you're doing. Mr. Peters?
I'm sorry, Your Honor.
Are you only speaking of the people waiting to hear about jury?
Right.
Okay.
Right. The ones waiting to hear about your juries, like Jill Gillette. Well, I may need you for something else, but Will Peterson and some of those kind of folks. One of the pro se defendants, I think, was who's Judge Stokely to everyone that will not be present at 2 p.m. Oh, that's that J.U. Stokely. All right, well, stay put. Okay, is Elizabeth Pipkin here and ready to go?
She is, Your Honor.
And Your Honor, the state's information is that this pursuant to plea negotiations, the state would move to amend count 1 to disorderly conduct.
All right, Ms. Pipkin, how do you plead to the amended charge of disorderly conduct?
No contest.
And that is pursuant to KSA 21-6203A3, counsel?
Yes, Your Honor.
Okay, so Miss Pipkin, it's alleged that you committed disorderly conduct in one or more of the following acts by knowing or should have known would alarm, anger, or disturb others, or provoke an assault or other breach of the peace by using fighting words or engaging in noisy conduct tending reasonably to arouse alarm, anger, or resentment in others, a Class C misdemeanor. How do you plead to that amended charge?
Fighting words are not a freedom of speech.
No contest.
By pleading no contest, you're not admitting the charge, but you don't want to deny it and take it to trial either?
Yes, Your Honor.
Thank you. We're recording this, so I need to be able to hear you. Okay.
I need to know what the fighting words were.
And you understand you're giving up your right to a trial. You will most likely be found guilty and unable to appeal conviction, even though you're not admitting it.
Yes.
And no one is making you do this other than the terms of your plea agreement.
No.
Counsel, are we relying on the affidavit filed August 21 and 25 as the factual basis to support the no contest plea? That'd be Deputy Michael Malot's affidavit?
That would be the state's intention, Your Honor.
Yes, Your Honor, that'd be agreed to.
I find the defendant has knowingly and voluntarily entered a no contest plea to the amended charge of disorderly conduct, and that the state has provided a factual basis to support the amended charge and the no contest plea. I find the defendant guilty of the amended charge of disorderly conduct. Recommendations for sentencing.
Yes, Your Honor. One thing I had neglected to mention, for which I apologize, the information, what this was originally charged as a domestic battery offense. State's understanding is the state is one moment, Your Honor.
I didn't take it that you added the domestic violence tag to this charge.
And Your Honor, the state is prepared to proceed in that fashion.
All right. No domestic tag?
Yes, Your Honor.
All right. So I find the defendant guilty of disorderly conduct, no DV tag. And at this time, recommendations for sentencing, Mr. Regier?
Yes, Your Honor. At this time, the state is prepared to recommend a suspended jail sentence of 30 days, that the defendant be ordered to complete a 6-month reporting probation subject to all standard conditions, all appropriate costs and fees, as well as an appropriate anger management course. The state would further be recommending that the defendant be ordered to consume no drugs or alcohol as a condition of probation.
Got no contact with the alleged victim.
Your Honor, the state has no objection to the court lifting the no contact order in this matter if the court deems it appropriate.
Mr. Patterson, your recommendations, including the no contact?
Judge, we'd ask court to adopt the recommendations for purposes of sentencing. And Judge, if Ms. Pipkin can address a no contact order with the court.
All right.
Ms. Pipkin, can you tell the court your view on whether the no contact order should be lifted or stay in place?
The no contact order has made things a little difficult considering that we share two children together. So having that lifted would make like changing back between kids a little bit easier.
But might it also make things a little easier, keeping a little more peace between you and keeping him from making claims that could affect you as well as you doing acts that could affect you?
Mm-hmm.
Okay. All right, at this time, your sentence is 30 days, but it will be suspended. If you don't want to serve the 30 days in jail, make sure you successfully complete a 6-month reporting probation. As soon as this hearing is over, call and report to probation at 316-322-41.
867-5309.
All standard conditions of probation will apply. I will word it this way. No contact with Jacob Baker unless it's to discuss the children and can be done in a peaceful manner. As long as you can do it and discuss the kids peacefully, that will be allowed. There is to be no drugs, no alcohol. You must take an anger management class. And if necessary, you may have to get an evaluation to figure out what level of anger management you need to take. Court costs will be ordered. $60 supervision fee. I believe that's $158 for court costs and $60 supervision fee. And tell me,
I am retaining this case.
Okay, thank you. All right. So how long will it take you to pay about $200 court costs and fees?
Like 2 weeks.
I'm gonna give you 30 days to pay. Make sure you get those paid in full within 30 days.
I've got a story for you I wanted to share.
That'll
Law
help
enforcement
you. Anything
story.
else from anyone that we need to address?
Your Honor, does the court wish the journalist reflect that a fine is not being ordered in this matter if that is the court's order?
Did you recommend a fine?
The state did not recommend a fine pursuant to plea negotiations, Your Honor.
No fine is ordered.
All right. Hold on for a second. There is a story that came across the news wire this morning. By the news wire, I mean the internet connection. Out of Sacramento. Sacramento County Sheriff's Office posted this in a nationwide first, and I'm reading their tweet, or their X post, whatever that is. A drone was successfully used to disarm an armed suspect, helping bring the incident to a safe resolution. Sacramento Sheriff's Special Enforcement Detail, SWAT, had the residents surrounded. The known felon and parolee at large was seen earlier with a firearm. After not responding to negotiators, a drone was deployed inside the residence. Drone pilots located the suspect hiding in the corner of a garage. One of his hands was concealed under his body, and the other was holding a knife. He was obviously alive, but not responding. He was pretending to be dead, or was he pretending to be dead or simply laying in wait for deputies to approach? Rather than rush into a potentially deadly encounter, one drone pilot came up with an innovative solution. By attaching a powerful magnet to the drone, the pilot was able to safely remove the knife from the suspect's hand before deputies moved in. It was an incredible display. I kid you not. It was an incredible display of creativity, skill, and precision by the drone pilot. It's also worth noting that our drones are labeled as military equipment, even though anyone can purchase them at their local Walmart. but are really just another piece of technology helping deputies resolve dangerous situations safely. Their use protects both law enforcement and personnel and suspects. The drone, they tied string to the drone, they tied a magnet to the string, and then he flew over the guy's hand. It stuck to the knife, and then he dragged it out of his hand and flew away. And there's video, which is just, let's see if we can show you the video here. Just one second. Let's bring it up here. On 3. I need sound. I need that sound off. Whoa, whoa, whoa. All right, so while the sheriff's office is really good about following most laws, apparently copyright laws are not some of them. So they played on this one. They have James Bond theme song going in the background. And this is the video they posted on Twitter, showing a little, I believe, DJI drone sticking a magnet to something. There's the SWAT team. He's flying in the garage. You're going to see the suspect's hand as he appears to be passed out on a beanbag. There's the knife. Magnet sticks. Wiggle, wiggle, wiggle. Out comes the knife. and then it flies away. Yoink. Yeah. And then the drone was given a reward, and the pilot got a sticker. So that's out of Sacramento County, which is, you got to give them props for creativity. I saw that. I thought before we go to lunch, we need to watch this really quickly. But not cool, Sacramento County, for using copyright music in your video. Otherwise, we would be able to hear the audio. But imagine James Bond's theme song playing during that. This knife spinning underneath the drone as he's flying around in the garage. Yeah, attaboys. All right, that's all. We're going to go to lunch. We're still looking for a case to follow. The case up in Alaska is on break right now. That's over on Top Mark Media, but you can jump back to that one if you'd like and watch how that one goes. Do you guys want to head up there? It's sort of interesting. We also want to let you know I ordered my counter today, the Smurl counter. The idea, because I've got a really smart son who's good at programming, the idea is that you would be able to enter a command using chat, and it would change a counter here on this screen to show the current either likes or probably not subscribers, but we might be able to do subscribers, likes, subscribers, or comments or something like that. So we can rotate through different types of counters. And it's going to be fun. It's going to be fun. Hopefully it's not too loud. How long until we hack that to say inappropriate messages? Well, it's 5 digits long, and it only has numbers, and it's a physical, like it's a little one of those flip counters where it actually rotates a little paddle and it releases the next little plate that falls down to make the next number. So you can't really do anything but show numbers, but if you can get it to say something with numbers, and I realize being at one point you were a teenage boy. Yes. Okay. A couple of you have figured out in chat that zip codes work. Yeah, you guys could make your, that's about the only way you can hack it. The counter is better than caviar. I hope so, by far. But they're going to laser engrave the front of it with the logo that Red Pen graciously helped us make out of our channel logo. And Ms. McGuire says girls did it too. yeah, it's going to be a number. That's all. It's going to be a number. Anyway, we're going to have that possibly right here on the display, so you guys can see the counter. It is a real-time counter. So as people click the like button, it would flip over, I believe. Or as people query it using the command, it might query it and then update to the current counter. B-Buddies, thanks for clicking the subscribe button. Appreciate that. We're going to go to lunch here right now and looking for something for this afternoon. It's thin. It's thin right now. We have the big hearing for Tyler Robinson coming up here early in July. Let's see. We've got Judge Boyd is live, but she's sort of also not live, if you know what I mean. If you know, you know. Looks like that. So we're just watching her court get ready. Maybe looks like she's just starting, kicking things off. Is that today? Oh, no, she stopped being live. That's why. Minecraft court.
There is an agreed recommendation for a prison term of 5 years, but other than what's been spread upon the record, no threats or promises were made.
Just doing a sentencing there for Minecraft court. Thurston is online.
Walk their dogs. Our dog, and he went out to walk his dogs, and there was some altercation of communication between them as well.
Wait.
I do believe that this is between two men that are having issues handling conflict. I do not believe that there is a reason for. I mean, this is over kittens. This is pretty immature of both sides. But it has came to the extent that my children, during the time that Mr. Vassar had returned home, it says in the report on June 5th, he was home from 8:10 to 10:53. That he supplied his screenshots of his location. My daughter was also missing again on June 5th. And between the time of 8 and 9 o'clock, we were looking for her. And she wasn't answering the walkie-talkie again. At 8:30, something had occurred I did not know of until, I will get to that until Monday morning. June 5th, she returned home about 9 o'clock and stated that Mr. Vassar was around the area and held her hand over her mouth and held him by her and said, her by him and said, "Don't tell anything."
Okay, this might not be family friendly.
That was, I apologize. That was a child that was in trauma at that time. She did not give true facts. In fact, on Monday morning, we found out that she was exploited by 3 other little boys.
Okay, we're gonna bail on that one. Thurston, I thought we thought it was puppies and kittens, and it went otherwise. So bail. Let's see, where are we going? We're gonna go to lunch. That's where we're gonna go. Yeah, we need to bail. We're bailing on that. Looking for my music, which I can't find. There it is. How do we go from kittens to that? Yeah. We're going to look around, see if we can find anything news or court related for this afternoon. We find that we're going to be there with it. So, do you want to give you just a little update? I was able to successfully paint my closet yesterday. So I believe all the painting in the house is done. I now have to install vinyl flooring in the closet, which should take all of about 6 minutes. But that's a project for another day. My 4 sons just got here. You have to watch the rewind to the beginning. Rewind to the beginning. We are actively searching for something. Courts have been pushed that we thought we'd have scheduled for this time, and it's just what happens. So as we wait for a good trial, we'll keep our ear to the ground. If you hear one, text me on the burner phone. We'll see if we can find something that we can watch and get included in the media pool for, so we can bring that to you. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe. We go live again as soon as we have something. Or tomorrow morning, whichever's later. All right. Bye. Portal to top mark.
Because he's the guy.